We need to have Mr. Amato brought out.
Okay, I'll explain to him what's going on.
You'll just explain to him back there. All right, so Mr. Amato has several cases, 10 CF 2798, 11 CF 18, 134. Mr. Bergeramo for the defense, Ms. Mason for the state. Your request, Mr. Bergeramo?
I'm asking to move this out for a resolution. We want to put this maybe on the 9 o'clock docket?
So this will be a plea agreement.
Yes, it is.
Any state comments?
There.
When can the parties be ready?
I think I heard a July date.
There is July 14 and July 28.
Let's do the 28th.
State available then? Yes. So on all of Mr. Amato's cases, July 28, 9 a.m. for plea agreement?
Yes.
And you will inform him separately, Mr. Bergeramo?
I'll speak to him right after this.
All right. Chances Anderson is next. Mr. Khalil and Mr. Ashby, she is also in custody. How will this proceed today?
Your Honor, made a last ditch plea effort. If that doesn't work out, then it'll be a plea for action.
Do you need to speak with her additionally?
I already spoke to her, Your Honor.
All right, and do you know what her choice is?
We'll either go forward with the plea or the plea for bench.
All right, so either plea agreement or to the bench, all right?
Yes, Your Honor.
All right, we'll recall that matter. And on the state side of that was Mr. Ashby. I don't see him.
He's outside, Your Honor.
All right, thank you. Yeah, Mr. McElroy, I think we could just have him enter. Thank you much. Let me just check with Mr. Ashby. Hello, Mr. Ashby. Just wanted to check with you as we do the inventory of cases. Mr. Khalil indicates the Chances Anderson case will either be a plea agreement or plea to the bench.
Yes, Your Honor.
State have any requests otherwise?
Your Honor, my plan we're here for a plea to the bench, so that's what state's there.
All right, so we'll recall that then after I go through the briefer matters.
Thank you, Your Honor.
All right, Mr. Barger and Ms. Brown, I have a ruling and a sentence ruling disposition issue on Mr. Brown. I'll be addressing that shortly. Recall it. Ms. Mead, Ms. Mason on Pierre de Rochers, if I'm pronouncing that correctly. What's the status of that?
That would be here.
So that'll be a full hearing?
Yes.
All right. State have any update on that? All right. Let me recall that then for hearing. Nikki Dinger, Mr. Ward, and Ms. Mason, several cases beginning with 19 CF 1566, 1612.
I believe I'll be a plea agreement.
Okay. I will recall it momentarily. Brian Gibbs, Mr. Day or Mr. Gorman, don't see them here at this time. Any sightings of Mr. Day or Mr. Gorman?
Mr. Gorman was in here.
All right, I'll recall that. James Lyons, Mr. Barger, Ms. Mason.
That's going to be a plea to the bench.
All right, bench plea. Any state comment on that? Okay. Luis Rosado, Ms. Mead, and Ms. Mason. Several cases started 19 CF 1313. And yes.
13, 13, and 14.
And how will this proceed?
On your Honor, originally, this is one of those cases that were set on the hearing in August. That was on the original affidavit violation with black and white. Since then, he has picked up a new violation. He was rearrested. And apparently when he went to 24, the court at 24 set it from the August date to this date. Unfortunately, the state and myself actually knew that that had occurred. I knew that it had been put on this date, but I assumed it had been on the 9 o'clock docket because that's typically where they go from a 24 hour period. And this Mason called me last week, asking if I could do a separate hearing next week, I said, as far as I'm aware, that's what we learned. I don't, my witnesses are subpoenaed for the August date. The state doesn't have any witnesses at all subpoenaed for this date. That was the reason for this meeting on, I mean, I can't object to continuing it because I'm not the same phone.
So, Ms. Mason, any comments to add?
No, Your Honor, I think that we're going, still ready for August 18th. And we just asked that it be put back on the August 18th.
Will you inform Mr. Rosado separately, or do you want me to bring him out?
You could bring him out, Your Honor.
Mr. Rosado is available, please?
Over the last couple of days.
All right. And I see Mr. Gorman has returned. We'll be addressing the matter in just a moment.
It'll be a resolution.
All right. Okay, that's on the Gibbs. All right, so I'll make a note of that. We'll recall it shortly.
And Your Honor, there's another issue that needs to be tonight.
Mr. Rosado is now present. Hello, Mr. Rosado. All right, Ms. Mead, you indicated that this was set here incorrectly. Is that correct? Is that accurate?
It was set for August 18th, but 24-hour court moved it to this afternoon, without knowledge of herself or and none of the
However, both sides are prepared for the previously scheduled August hearing date. Is that correct?
Yes, sir.
So that date is already noted. Madam Clerk, do you have that in the record?
I have to add that it was.
And again, to be clear, what date and time, if you recall?
It was August 18th at 1:30. Yeah.
Any plea negotiation continuing?
This is the 9th.
But we should be able to completely try the matter on that date in August then?
Yes.
All right, then it is canceled for today and return to that date. Thank you for your patience. All right, Mr. McElrath and Mr. Ashby, Deborah Shakwa, if I'm pronouncing that correctly. And Mr. McElrath, will that be a hearing today?
Yes, Your Honor.
All right, will that be a plea to the bench or a full hearing?
Your Honor, we anticipate a hearing on this. We don't believe there's a violation, Your Honor, so really.
Okay, so it will be for full hearings. Was the state prepared to address that?
Yes, Your Honor, we're ready for full hearing.
All right, so let me recall that then when we're ready to start. All right, and lastly, Charles Tatum, Mr. Ward, and Ms. Mason. And let me see if Mr. Tatum is available. Now, this is here for the court to announce its decision on sentencing. I am going to need to try to move this to next week because I have not been able to reach a final decision on this. I wanted to inform Mr. Tatum to set it from court here. If both sides are available, go next week, I should be able to do it then.
Yes, Your Honor. Mr. Tatum.
And I understand that there is anticipation involved, but I do, in fairness to both sides, I do want to think about the issues that have raised me a little bit more. Mr. Tatum has returned. Hey, hello, Mr. Tatum. And this is here, the court did hear an evidentiary hearing and has been considering the arguments and the evidence presented. The parties are not in agreement. There is a significant difference in the recommendations. I do think there are some substantial things to consider here. And although I know it's frustrating to everyone to not have a decision today, I do want to give it just a slight bit more thought in fairness to both sides. However, I am prepared to rule on this as early as next week, and I will set it now from the courtroom so that there's no further delay. I do understand that it creates anticipation for everyone, but I do appreciate their patience. I think it's fair to both sides if I think thoroughly through this. So let me go ahead and see if both sides are available next week, and then I'll make a final decision then.
Judge Manalich's office.
Hello, Melissa. I'm calling you on the Tatum case, and I explained to the parties that I have not come to a final conclusion on this decision. I don't want to delay it inordinately, so I do want to finish it next week. Let me discuss with the parties now. The available time, 20 minutes is all that is needed.
How about on the essential hearing docket next week, which would be Thursday, June 17th at 2:30?
Let me see if the parties are available then.
Yeah, I have a deposition starting at 3 o'clock. So I could do it, we could go, but this go first. I could certainly-
Is there any earlier time, Melissa, on that day?
No.
Okay. I think it'll only, I'm going to explain my ruling, so it would just probably take 15 or 20 minutes. Does that give you enough time to handle the other matter with Mason? Mr. Ward, any conflict for that day?
We have a deposition of two.
All right, so that is problematic, Melissa. Let's look for another day next week. And we may need to look at,
Well, how about during the VOP docket on June 15th in the afternoon at 1:30?
okay, how does that work for the parties?
Yes, sir.
That's next Tuesday? All right. Let me, Mr. Ward, I believe Mr. Tatum does have some folks in the audience. I believe I see them there. And my apologies for the delay, folks, but I do want to be fair and think about it for the benefit of both sides. Are you able to return next Tuesday at that time? They're nodding their head yes. Okay, thank you for your understanding. The parties agree, so restate the date, and time, Melissa, please.
Tuesday, June 15th at 1:30.
Okay, thank you for your patience, Mr. Tatum. We'll address it then.
Thank you.
All right. Let me go back to Mr. Brown. That is a ruling that I need to make. We might as well address that now. Oh, Mr. Fayette, which case?
Thomas Schwartz is 20 CF 9 as well.
Schwartz? Do you see that on the docket?
Yes, it was added on this
Oh,
morning.
all right. Are you, do you have a conflicting court appearance?
I do this, but I'll do whatever the kick with the.
Okay, let me just take this case first, and Mr. Bergeron.
Also, there was an add-on, my six.
Oh, all right, all right.
And also Casey.
All right. Let me, the production as we go along. Mysick, Casey, and what was the other one?
Schwartz.
Sure, sorry. Let me address Mr. Brown, then we'll address those cases.
Oh, and Mr. Money too needs to be recalled.
For some other reason?
Yes, clarification.
Lang?
Yes.
Okay. Any other judges who want to send their cases over? Laura? Okay. We're here to serve. Awaiting Mr. Brown. Mr. Barger, typically Mr. Brown's relative has been here. Do you know if she was planning to attend?
She's not able to attend, Your Honor. She had, by accident, she can smoke.
All right, I just wanted to make sure that if she wanted to appear, she had that opportunity. Hello, Mr. Brown. Case number 7 CF 429, State v. Brown. Violation of probation case, Mr. Barger for the defense, and for the state, Ms. Brown, okay, no relationship. All right, Ms. Brown succeeding to Mr. Maresca. All right, just a clarification to begin with, and this is here for the court to make a decision as to disposition of these violations. I had 2 score sheets. They differed in the points and the minimum. Have part of council agreed as to which is the correct one?
Your Honor, I have a score sheet that indicates 164.4 is the low end, There are 2 counts of attempted sexual battery on this worksheet with 2 counts of sexual contact points and then a prior record.
Okay. So there was an earlier one that was prepared that showed 189 points. But that was inaccurate.
May I read you one that you're on?
Yes. I'll let you and Mr. Barger look at both of them.
Now I'm going to pass it to each worksheet. There may be an issue with the prior record, in which case we need to do that again.
Now, let me do this. If you wish, I can recall this matter if you need to discuss or look at this more thoroughly before we start.
Yes, sir.
And let me know if we can go forward today, because obviously the score sheet isn't a fundamental thing here. So let me recall this, and I'll go to the other matters from earlier that I have not yet called. The Misick case, Mr. Verderamo here? Yes. And was it Ms. Mason for the state?
It is, yes.
Okay, I don't see her right now. Mr. Ward, have you seen Ms. Mason out there while you were out there? Okay, thank you. Will Mr. Misick need to appear, Mr. Verderamo?
Sure, he's here.
All right, one moment. Let's see if Ms. Mason's available. Case number 15 CF 1447. All right.
You must have gone to the record.
Okay, so we'll have to come back on Misick.
Recall.
Mr. Casey's not until 3 o'clock. What were we recalling Schwartz for, Madam Clerk? All right, Mr. Fayette, let's go ahead with the Schwartz case. All right, it takes 2 to tango, so it's always a production here. Okay, that's fine, yes. All right, Thomas Schwartz, 20 CF 912.
First time I hear it.
Yes. Grand reopening June 21st. Mr. Schwartz now present. All right. Madam Clerk, ready? All right. They just threw it in to keep your attention. All right. Well, Mr. Ashby for the state, what are the agreed terms?
The terms are a withhold vacation, 2 years probation, mental health evaluation, follow recommendation, substance abuse evaluation, follow recommendation, testing, no alcohol provision, court costs, cost of prosecution, cost of investigation of $461.50 per partnership.
Any clarification, Mr. Fayette?
No, sir. He does wish, he's going to be moving to Texas, if we can put it on there, he understands the process for everything, he would be right away, with the rest.
Reporting upon release here in Collier?
What's that?
Reporting upon release here in Collier?
Yes, sir.
And Mr. Schwartz understands that there is a process separate from this court that he will likely have to remain unless probation allows him permission to leave until that is approved.
We didn't talk about the possible benefits.
Okay. Mr. Schwartz, do you understand and accept the plea agreement terms? Any questions about any of this?
We got to be eligible to early term, I told everyone eligible doesn't do the guarantee.
Okay.
Yes, sir.
Are you willing to accept the terms as explained? Very well. Raise your right hand, please, and swear and be sworn.
Swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth.
Thank you. May I lower your hand? And please answer the state's question.
Okay. Sir, can you please state your name and date of birth?
Obviously, sports, overnight, 1984,
What are the last 4 digits of your social security number?
8364.
Have you ever been known by any of their names or aliases?
No.
Where were you born?
Johnson, Ohio.
How far did you go to school?
I was at college.
Can you read, write, and understand the English language?
Yes.
Are you under the influence of any drugs or alcohol?
No.
Are you taking any medication?
Yes.
Are you taking that medication as prescribed?
Yes.
Are you taking that medication today?
Yes.
Does that medication affect your ability to understand these proceedings?
No.
Are you suffering from any mental conditions or disorders?
I do stuff from that.
Does that condition affect your ability to understand what you see?
No.
You understand why we're here today?
Yes.
Sir, 20 CF 912, you've been charged in one-time information with the following charges. Count 1, battery of a person 65 years of age or older, a third-degree felony punished by up to 5 years in the Department of Corrections. For that charge, I need you to plead guilty, not guilty, or no contest. So do you understand that battery is an enhanceable offense, meaning if convicted of this offense in the future, you receive more jail or prison time for a higher fine? Yes. You stand, sir, that a second battery will be charged with felony? Yes. You understand that by entering this plea, you're waiving the right to a trial by jury? Yes. You understand you're also waiving the following rights: right to have a jury determine your guilt or innocence, right to see and hear the state's witnesses testify and have your word questioned them, right to subpoena, call your own witnesses and submit evidence on your behalf, right to testify in your own defense or to remain silent, and your right to make the state prove the charges against you beyond a reasonable doubt. You understand that you waive all those rights by entering this plea today? Yes. Counsel, reserve any matters for appeal? No, sir. Mr. Schwartz, do you understand you're going to be right to appeal on all grounds except whether this court can impose this sentence? Yes. So I'm showing you your score sheet, 3 pages length, that our teacher will read this with the attorney. Yeah.
He hasn't seen it yet, I went over the numbers with him, but I know the numbers for you.
So you just took a moment to review your score sheet with the attorney, is that correct?
Yes.
Showing hold right here, my hand shows the score, total sentence 1 to 22, with a lowest permissible prison sentence among 0. You research the score sheet exactly. Also holding a plea of guilty or no contest from the first one, you do form front and back. Yes. There's a signature in the back where it says defendant's signature. Yes. The signature tells me that you read and understood the right to listen on the plea form. Did you in fact read and understand the right to listen on the plea? Yes. Any questions about the plea form at this time for your attorney? Yes. There are other ones contained in the plea form of what we just discussed on the record that came with problems you in exchange for the plea today? No. Are you entering this plea of your own free will? Yes. Are you being forced upon by anyone? No. Are you pleading, given your options? Do you believe that this plea is in your own best interest? Yes. You understand there's no guarantee that you will be able to terminate your probation early? Yes. Are you satisfied with advising counsel of your attorney? Yes. Have you done everything you've asked and answered all the questions? Yes. Have you gone over all the discovery in this case with your attorney? Yes. Have you had sufficient time to consider the offer of the charges, whether you want to accept the state offer or go to trial with your attorney? Yes. You need any more time to speak with your attorney? Yes. So I'm aware of any physical evidence that can be tested for DNA to exonerate you. Do you understand, as a result of this plea, no physical evidence can be tested for DNA? Yes. You understand that you're not a U.S. citizen, you're subjected to removal or deportation as a result of this. Yes. You understand that if you're deported as a result of this case, it will not be a basis to withdraw this plea. Yes. You need any additional time to discuss this with your attorney. Yes. If the offense to which you're pleading is a sexually violent offense or a sexually motivated offense, or if you've been proved convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of the sentence. Do you understand your point? Yes. Counsel, do you stipulate the factual basis of venue for the purpose of the plea? Yes, sir. I say, counsel, please report.
Mr. Fayette, any other defense requests? No, Mr. Ashby, there was a motion to lift the no contact order. I didn't see that that was ever addressed. Do you know if the victims in this case request any no contact order?
They did not, Your Honor.
Were they informed of today's court date if they should choose to attend or have any victim impact that they wanted to present?
I said there's no start date.
And there was no request to have a no contact order in place? And Mr. Fayette, Mr. Shorts believes his plea agreement is in his best interest?
Yes, sir.
At this time, based on the plea agreement, plea colloquy, the admitted or the plea of no contest is a new law case, and the arrest affidavit facts in support thereof, the court accepts the plea agreement as agreed, withhold adjudication, 2 years regular supervision reported immediately upon release in Collier County, and he is requesting an immediate authorization of transfer to the Lone Star State.
Yes, sir.
That is granted. However, it will be subject to the interstate compact. Mental health evaluation, follow recommendations, same for substance abuse, and random testing. Any time frames on enrollment, Mr. Ashby?
30 days.
Any objection?
No.
For both or for one in particular?
For both rounds, it should be signed off.
Is that given the receding pandemic circumstances, is that reasonable, Mr. Fayette?
I think so, there's no where he's going, so we talked about that, we're gonna try and reach out over there to see if we know.
So the court will not require the actual evaluation take place, it's merely that the appointment be made for each.
That we can definitely follow.
No alcohol provisions as agreed to, court cost man clerk,
767.
is that anticipated, Mr. Fayette?
Yes, sir.
Prosecution 100, investigated 461.50, pay all payable during the term of supervision, no objections to any monetary amounts. Any other terms for the parties?
That's okay.
Madam Clerk, thank you for resolving your case, Ms. Shorts. Please step over here for the prints. Ms. Mason has returned. Mr. Verderamo is here on the Mysick case. We may need to wait a moment for the bailiffs for Mr. Mysick.
Yep. Request.
Okay. One moment. That is case number 15 CF 1447. And we'll wait when the bailiffs are ready. All right, and Mr. Mysick has returned. Hello again. So we had entered a plea agreement to resolve the violation. The issue became from this morning whether or not the court would find a danger to the community, and the parties request an opportunity to present further argument or evidence. Any comments from the state? The state previously this morning deferred to the court on this.
Yes, sir, Steve.
Okay, now Mr. Verderamo.
There's been some opportunity to read through case law as well as statute. Rule from 3.790, the statute 498.06, paragraph 80. And I don't believe there is evidence that's been presented to the court clear and convincing us to establish Mysick threshold. Mysick not going that much supervision, I believe the legislature has individuals who have supervision before he was made. This is is a straight jail time sentence. And I don't believe that this one, the court taking the position. I know having a hearing not being held specifically depends on the court. I don't believe that the situation will be different for.
I would disagree, Your Honor. The court does need to know in order whether he's going back on supervision or not. I guess I understand the statute is clear, however, if the court does find behaviors that cannot go back on supervision, but we're not asking him to go back on supervision in this case, but in order to.
The statute under 80 indicates after conducting this hearing.
I think also with that, we could also. We talked about that, we're talking about the defendant's current conduct, the current charges as well as his prior history. So that is about a full hearing that we are having right for the court. So the court does have to enter the order.
Okay, that's fine. Well, I would argue that there is insufficient clear evidence found after a hearing, the criteria that the legislation has laid out under the rule of criminal procedure.
And the state believes the court should make the finding one way or the other?
Yes, Your Honor, it's the state's position that the court is, because the defendant is designated as a violent felony offender special concern, the court must decide whether he is a danger to the community or not, regardless of whether he's going back on supervision or not.
Well, in reading 948.06 sub 8, sub B, and sub E, the court is not allowed to dismiss a pending BOP warrant without holding a recorded violation of probation hearing if the court, after conducting the hearing required, determines that there is a violation other than a monetary violation, the court shall make written findings on the danger issue. So I think we have had the VOP hearing. It just was that it was resolved by a plea agreement, that a violation was found. And the statutory factors are laid out, many of which are matters of record. I agree with Mr. Verderamo, the state has not chosen to present danger evidence. But my question earlier to the defense, which I renew at this time, is that in the Peach State, otherwise known as Georgia, Mr. Mysick had robbery with, I believe, I don't have the score sheet in front of me, but let me see if I can find it.
No gun.
Okay. There was robbery, one or two convictions in Georgia, I believe. Is that correct?
One conviction for robbery, no gun, or excuse me, it says number 2, and then a grand theft.
Okay. But there was a robbery. This is a case involving let me go back to the
attempted robbery,
and
also robbery, attempted robbery by smuggling action.
right. Now, when I looked at the arrest affidavit, I discussed with counsel earlier, it said that there was a firearm involved. However, the state apparently reduced the charge to not involving a firearm. Is that correct?
Correct, Your Honor. It was robbery with a weapon, but the state did not use a weapon rather than a firearm.
Does the defense have any additional argument?
The judge, according to the rule and the statute, take into consideration the present conduct including prior convictions of the court. Additionally, the amenability to incarcerated sanctions based on Mr. Mysick's history and conduct during probation or supervision from which the violation arises, and any other previous supervision with disciplinary records, incarceration, which we don't have here today. I take the position that I don't believe that there's any evidence other than the score sheet, no factual basis from what took place in Georgia, and I believe there's enough for the court to enter in order to determine
Well, what about the nature of the prior convictions as well as the current?
Like, I agree those elements are there, but the court can take into consideration that there's a routine of things that the court should take into consideration.
Ms. Mason, any additional argument?
No, there's no right there.
Well, I don't fully agree with the defense argument that the court could not make a finding based on records, including prior records of convictions. However, given that the state has not entered evidence of danger beyond what's in the record, and that the conviction in this case did not involve a firearm as convicted, and this violation being a substance related test, not a new law violation or violent conduct, the court will find not a danger to the community. I think that was the only clarification remaining on Mr. Mysick's case.
That's it, previously, there's that.
All right. So I will enter the order so finding.
Thank you.
All right. One moment, just to finish the order. Not.
Okay.
All right, we did have the Lane case, which I've been asked to call.
Yes, Your Honor.
All right, Ms. Mead, what was that being called for? That's
There
a,
was this one, Your Honor, I believe the first case of clarification of a misdemeanor adjudication sentence for. He admitted to violating probation, he was placed for the felony count. And there was
so what's the state recollection?
That we were, the continuation going on to duty control and the subsequent regulatory provision was only for the felony counts.
It was time served.
From one of the communities.
Is that in keeping with the defense position?
Yeah.
Does that clarify for the clerk?
Yes.
So ordered.
Okay.
All right, Mr. Gorman, yes, you had a matter that you said was ready to be addressed?
Yes, Ryan Gibbs,
This is here for a plea agreement. Mr. Gibbs approaching.
Good. Before the court is Ryan.
Well, Mr. Gibbs, please have a seat.
Mr. Ashby, finish up on the order that's going to be modifying probation, but also first, there will be modifications, the defendant will admit the violation. Defendant's probation shall be extended to September 30th of 2023. Defendant shall attend and complete a substance abuse evaluation. The defendant shall follow all recommendations of that counselor. The defendant will be randomly tested for drug and alcohol. Additionally, his probation is going to be drug offender probation. Defendant will also have a no alcohol provision, which means not to consume any alcohol, not to enter bars, restaurants, cabins, etc. Primary purpose of sale of alcohol. The defendant shall also abide by a curfew from 10 p.m. until 6 a.m. for any 8-hour period approved by the defendant's probation officer. $100 cost prosecution, and then original terms would carry forward, except for the provision that the residential program that he was in is removed from the provision. So, just regular choice program is removed, or
there was a prior modification, it was provision C and provision D in the prior modification. I have the order dated June 18th, 2020. Those provisions were restricted. There's also a no early termination on the probation.
On the new drug offender probation?
Yes, sir.
Was that understood, Mr. Gorman?
yes, Judge, Mr. Gibbs, you understand that?
Mr. Gibbs, any questions about any of this? Do you understand and accept this agreement to modify your supervision? Please raise your right hand, be sworn by the clerk.
So, if you guys need to increase the residency program, is the rule or is it in the order?
It is in here.
Okay, good. Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you, Mr. Gibbs. You can have a seat. Thank you.
My partner?
Yes.
Sir, can you please state your name and date of birth? Brian Gibbs, 8/23/1989. Sir, what are the last four digits of your social security number? Have you been known by any of the names or aliases? No, sir. Where were you born? I was born in Syracuse, New York. How far did you go to school? I have a bachelor's degree. Can you read, write, and understand the English language? Yes, sir. Are you under the influence of any drugs or alcohol? No, sir. Are you taking any medication? No, sir. Are you suffering from any mental conditions or disorders? No, sir. You understand why we're here today? Yes, sir. Sir, in 19 CF 641, you admit to being placed on probation for 2 offenses. Count 1, battery on a law enforcement officer, a third-degree felony, punishable up to 5 years, Department of Corrections. And count 2, battery, a first-degree misdemeanor, punishable up to 1 year in Carter County Jail. You admit to being placed on probation for those offenses. Yes, sir. You admit to willfully and substantially violating probation by violating Section C of your probation. Yes, sir. Do you understand that the maximum sentence you receive for these charges is 6 years in the Department of Corrections? Do you understand that by entering this admission, you're waiving the right to a hearing? Do you understand you're also waiving the following rights? Your right to have a court determine whether you committed the violation. Your right to see and hear the state witnesses testify, have or question them. Your right to subpoena or your own witnesses to submit evidence on behalf. Your right to testify in your own defense. Your right to and your right to prove the charge against you by virtue of the evidence. You understand, sir, that you're waiving all those rights? Yes, sir. You must also understand that after that hearing, the state could call you as a witness. Yes. Counsel, reserve any matters for appeal? No. Mr. Gibbs, do you understand you're given the right to appeal on all grounds except whether this court can impose this sentence? Yes, sir. So I'm showing you your score sheet. You have an opportunity to review this with your attorney. Yes, sir. Holding in my hand, it shows the score total sentence points of 42.8 with the lowest permissible prison sentence in months of 0. Do you agree that this score sheet is accurate? Yes, also holding an admission to violation of probation and an opportunity to review this form in front of the attorney? Yes, that's my question. And you can come back to you. Sir, you have to say from coming back or assist the benefit? You took a whole day to review this form with your friend? Yeah. Sir, your search tells me that you read and understood the right listed on the admission form. Did you in fact read and understand the right listed on the admission form? Do you have any questions about the admission form with your friend? Other than what we just discussed on the record, has anyone promised you any exchange for this admission? Are you entering this admission of your own free will? Are you being forced upon by anyone? Are you admitting to violating probation because you're giving your options? Do you believe that this admission is in your own best interest? Are you satisfied with the advice and counsel of your attorney? I think that means you've asked and answered all the questions. Have you gone over all the discovery in this case with your attorney? Yes. Have you had sufficient time to consider the charges, the offer, whether you want to accept the state's offer or go for a violation of probation hearing with your attorney? Yes. Do you need any more time to speak with your attorney? You understand that if you're not a U.S. citizen, you may be subjected to removal or deportation as a result of this case. You understand that if you're deported as a result of this case, it will not be a basis for false admission. Do you need any additional time to discuss this with your attorney? If this offense is a sexually violent offense or a sexually motivated offense, or if you can prove some figures of such an offense, this admission may subject you to involuntary civil commitment and a sexually violent predator completion percentage. Counsel, you stipulate to a factual basis of venue for the purpose of the admission? Yes. I say pending admission to the court.
Any additional defense requests, Mr. Garland?
No, Your Honor, I may be proving out of state particular treatment, but we understand that's an expression of the proceedings.
Do you wish to have the court indicate its authorization for a transfer?
I don't think that's necessary, Judge. It's really up to the state.
at this time, based on the plea agreement, the plea colloquy, the admitted violation, the affidavits in support thereof, court accepts the plea agreement based on the admission, adjudication of violation. The court is signing the prepared order reviewed by both sides. Probation is hereby modified as agreed. The new supervision term beginning, well, is it carrying forward and extended?
Yes, sir.
All right.
And
And it's also modified to drug offender probation, effective immediately.
Yes, sir. And one clarification, this will be only for count one. The natural expiration date has occurred as far as for count two, which is misdemeanor battery.
Okay.
So what do I do with it?
That will just be rolled.
Okay, thank you.
Substance abuse evaluation, follow recommendations, random testing. Any time frame on any evaluation?
And Your Honor, I think my thing is already,
Agreed.
that's fine.
No alcohol provisions as agreed. Curfew is further agreed. The residential treatment has been satisfied as being removed per the order. Carrying forward all original terms otherwise applicable. Prosecution costs of 100 are added. I don't see any other terms that were announced.
That's,
Mr. Gorman, anything else to add?
Your Honor. It should be on there, there's also more of that.
Okay, that's right. That was mentioned earlier. Mr. Gorman indicated you had discussed that with Mr. Gibbs, and he understands that. Everything is approved as discussed. Thank you for resolving your case. Please step over here. Mr. Barger, are we able to go forward on Mr. Brown or not this afternoon? There is a score sheet issue. Is that the problem? All right, will you tell him or do you want me to bring him up? All right, so Ms. Brown, do you agree that there is a score sheet discrepancy?
There is a partner I will be discussing. I think I know the answer, but I want to be certain before we
In fairness to the state, Ms. Brown is taking over from Mr. Maresca for the first time on this case, so obviously the score sheet is fundamental to the analysis. So at this point, are we setting this for July 14 as the next BOP date?
I think that will be fine.
So I am prepared to rule, but I do need to factor in the correct score sheet. Will the parties provide that in advance?
Yes, we are. We'll coordinate with each other and ensure the court gets a copy. I'll have to handle it.
Okay. So I just noticed in my preparation for this today that I had conflicting information, so I just thought it was important to clarify. So July 14, 1:30 p.m. for the court's ruling. All right, one moment. And Mr. Barger, you were going to inform Mr. Brown? Okay. All right, let me continue with the briefer matters. Mr. Khalil, have you decided if it's going to be a plea agreement or a plea to the bench on Anderson? Let's address that now. If both sides are ready, Mr. Ashby. Chances Anderson, 19 CF 1840. Waiting, Ms. Anderson. Mr. Ward, will the Dinger case be a plea agreement?
Yes,
All right, we'll take Mr. Dinger next. Ms. Anderson now present. Hello, Ms. Anderson, please have a seat. You have a seat, thank you. And what is the agreement, counsel?
Yes, Your Honor. It's going to be a locally sentence, 9 months part-time jail, credit for all time served. It will be 3 months suspended upon completion of project recovery. Court costs, cost of prosecution, term will remain outstanding, and any monetary obligations before collection.
Any clarifications, Mr. Ward?
No, Your Honor.
Ms. Anderson, do you understand and accept these terms? Any questions?
Okay.
All right, you can remain seated. Just raise your right hand and be sworn, please.
Swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth. Yes, ma'am.
Thank you. Move lower your hand. Please answer the state's questions.
Thank you, Your Honor. Ma'am, can you please state your name and date of birth?
And,
What is your date of birth?
oh, yeah.
What are the last four digits of Social Security?
845,
Have you ever been known by any other name or aliases?
no, sir.
Where were you born?
April
How far did you go to school?
11,
Can you read, write, and understand the English language?
yes, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Are you taking any medication?
No, sir.
Are you suffering from any mental condition or disorder?
No, sir.
You understand why we're here today?
Yes, sir.
Ma'am, you admit to being placed on probation in 191840 for one count of possession of controlled substance, 33 felony punishment of 5 years department of correction. Say yes.
Yes, sir.
You admit to willfully and substantially violating probation by committing the following violations. Violation of condition 5 by failing to move without violating any new law, and violation of condition 7 by using intoxicants to excess. You admit to willfully and substantially violating probation by committing those two violations.
Yes, sir.
Mr. Khalil, do you want to talk to her at the sidebar there?
Sorry about that.
Okay. Now, Ms. Anderson, there's no obligation to accept any agreements or admit to anything. You have a right to a hearing if you wish it. Okay.
Ma'am, you understand that the maximum sentence to receive for these charges is 5 years in the department of correction.
Yes,
You understand that by entering this admission, you're waiving your right to a hearing.
yes,
You understand you're also waiving the following rights. Your right to have the court determine whether you committed the violations. Your right to see and hear the state witnesses testify and have no question them. Your right to call your own witnesses to submit everything you have. Your right to testify in your own defense. And your right to say prove the charges against you by the very way of the evidence. You understand that you're waiving all the rights that enter your admission today.
yes, sir.
And you also understand that after that, you the state will call you as a witness.
Yes, sir.
Counselor, reserve any matters for appeal?
No.
Ms. Chang, if you understand your duty right to appeal on all grounds except for this court can impose this sentence.
Yes, sir.
I'm showing you your score sheet. I have an opportunity to review this with your attorney.
Yes, sir.
Holding it in my hand, it shows you scored a total sentence point of 33. The legal permissible prison sentence a month of 0. You review the score sheet is accurate.
Yes, sir.
Also holding an admission to a violation of probation or community control form. I have an opportunity to review this one.
Yes, sir.
That's your signature where it says defendant's signature.
Yes, sir.
Your signature tells me that you read and understood the rights listed on the admission form. Did you in fact read and understand the rights listed on the admission form?
Yes.
Any questions about the admission form at this time for your attorney?
Okay.
Ma'am, other than what we just discussed on the record, has any problems with you exchange for the admission? Are you handling this admission of your own free will?
Yes.
Are you being forced or threatened by anyone?
Yes. Okay.
Are you being forced or threatened by anyone to enter this admission?
Not fair. No.
Are you admitting to violating probation because giving your options? You gave that this admission is your own best interest.
Yes.
Are you satisfied by inviting counsel to the attorney?
Yes.
Have you done everything you've asked to answer all the questions?
Yes, you did.
Have you had gone over the discovery stage with your attorney? Have you had sufficient time to consider the offer of the charge, including with the acceptance date offer, or go to a violation of probation hearing with your attorney? Do you need any more time to speak with your attorney? You understand that you're not a U.S. citizen and may be subjected to removal or deportation as a result of this case. You understand that if you're deported as a result of this case, it will not be a basis to withdraw this admission. Do you need any additional time to discuss this with an attorney? And if this offense is a sexually violent offense or a sexually motivated offense, or if you've been previously convicted of such an offense, this admission may subject you to involuntary civil commitment as a sexually violent predator or completion of your sentence. Do you understand this point? Counsel, do you stipulate to a factual basis of venue to go through the admission? No stipulation. You're going to take time to the admission before.
Mr. Khalil, any other defense requests?
Your Honor, just in order to have.
Any objection?
No objection, Your Honor.
Approved. Mr. Khalil, there are no competency issues affecting entry of the plea?
No, Your Honor.
And Ms. Anderson, just to be clear, because you gave a conflicting answer before, no one has forced or threatened you to enter this plea, is that correct? Okay. If there was, I'd like to know who it is.
No, I bet they are.
All right, that's fine. At this time, based on the plea agreement, the plea colloquy, the admitted violation, and the affidavit supporting the same, court accepts the plea agreement. Per that agreement, adjudication of the admitted violations, revoke and resentence, 9 months Collier County Jail, credit all time served, 3 months suspended upon successful completion of project recovery. As requested, the court is entering the proposed order for direct admission into project recovery at this time. And court costs are how much? There are none. Prosecution 100, and any existing prior monetary amounts and the prosecution costs are referred to collection.
Yes, sir, I'm hoping to back this up.
Oh, I'm sorry. Public defender fees total 150,
Yes.
and there's no objection from Ms. Anderson to any monetary amounts.
There you
All approved. Thank you for resolving your case. Please step over here. When the bailiffs are ready, Mr. Dinger.
I'm ready.
All right, Mr. Dinger now present. Welcome back, sir. Please be seated. 2 cases, 19 CF 1566, 20 CF 1612. Is the clerk ready for the terms? All right.
Your Honor, Mr. Daniel is admitting violation in this case, in both these cases. In 19 CF 1566, probation will be revoked and will be sentenced to 30 months department correction with credit for 282 days. 20 CF 1612, probation will be revoked and will be sentenced to 25 months department correction with credit for 133 days. Your Honor, that sentence in 20 CF 1612 is a slight downward departure. It is based on our enforced probation plea agreement.
Is this concurrent?
Yes, both cases will be concurrent. And there'll be a new $100 cost of prosecution and defense in each case, as well as a $50 application.
I don't think the credit time was 1612.
1612 is 133 days. And then outstanding monetary deferred collections, restitution deferred to civil and state tax.
Any state clarifications? Mr. Dinger, any questions?
No, sir.
Do you believe this agreement is in your best interest?
Yes, sir.
Please raise your right hand and be sworn.
Swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. May I lower your hand? Please answer the state's questions.
Can you say your full name and date of birth?
Mr. Sean Dinger, 0329
And what are the last 4 digits of your social security number?
392.
Have you ever been known by an alien or an alias or anything? Name? Where were you born? And how long did you go to school?
Baltic.
Are you able to read, write, and understand English?
Yes, sir.
Are you able to use drugs or alcohol? Are you prescribed any medication? Are you suffering from any mental condition or disorder? Do you understand how to today?
Yes, sir.
If you were immediately guilty in person to control of case number 19, the 19 1566 for one kind of felony battery, this is a 3rd-degree felony, comes to 5 years in state prison.
Yes, ma'am.
And in case number 20 CF 1612, we were accused of and placed on community control for one count of driving on suspended license, also 3rd-degree felony, up to 5 years in state prison.
Yes, ma'am.
At the time that you were placed on probation or community control in cases, were the terms and conditions full?
Yes, ma'am.
Did you understand them?
Yes, ma'am.
For Rachel Wilson, substantially violating your community control in the following ways. We're going to go each one, okay? Condition 9 2 times, specifically that you were instructed on December 9, 2020 to submit to request your schedule change by 5 p.m. and you failed to do so. The second one, condition 9, you were instructed on December 9th not to be December 9th, 2020 not to deviate from your schedule without your probation officer's consent. And you failed to carry out that instruction by leaving your residence on December 10th, 2020 without prior consent. Condition 16, you failed to remain confined to your residence unless previously by your probation officer. Specifically, that you're away from your approved residence without prior approval of your probation officer, and that you with the labor finders. Condition 17, you fail to maintain hourly accounting of all activities on a daily call. Condition 3, that you leave the residence without your probation officer's consent. Specifically on or about January 19, 2021, you moved from your last address at 1011 Avenue Northeast without your probation officer's consent. Condition 15, that you fail to report your community control officer at least once a week. Condition 16, that you fail to remain confined to your residence except as approved by your community control officer. Specifically, that on January 15, 2021, you were away from your approved residence at 9:56 a.m. without prior approval of your community control officer. Condition 16, which was the same, that you failed to confine your residence except as approved by your community control officer. Specifically, that on January 19, 2021, you were away from your approved residence at 6 p.m. without prior approval of your community control officer. And condition 17, 2 times, that you failed to maintain and submit an hourly accounting of all activities on the day of law, specifically on January 15th and on January 19th, 2021. You were not at your residence at the time of the law states you should have been at your residence. Mr. Dinger, do each of those allegations you wish to admit or deny? Do you understand by entering the admission to these allegations, you're waiving the right to a hearing on the violation?
Yes, sir.
And at that hearing, you would have had the right to speak and hear the state's witnesses testify and have your lawyer question them. You would have had the right to listen to your own witnesses to get evidence on your behalf, the right to testify in your own defense, and you would have the right to make the state prove each of these allegations by a response to the evidence. Do you understand that you're making this right today?
Yes.
And you also understand that if this case is not forward to a violation of probation hearing, the state also would call you as a witness in that case.
Yes, sir.
Counsel, if you're talking about your Mr. Dinger, do you understand that you're giving up the right to appeal anything other than whether this court has the jurisdiction from this end?
Yes, sir.
I'm showing you a violation of admission, in addition to a violation of probation or control form. It's front and back. It has your name here, the top as well as both case numbers, and there are 2 signatures here. One on the bottom of the front, one on the back. Those are your signatures. Does one of those signatures indicate that you've read this form or that it's explained to you? Do you understand all the rights that you take in? Did you have the opportunity to review this form with your attorney?
Yes, sir.
Do you understand it?
Yes, sir.
Do you have any questions about it? I'm also showing you your score sheet. Have you had a chance to review your score sheet?
Yes, sir.
And the score sheet shows a total of 64.9 points, the maximum that you could receive. In each of the charges for each case was run consecutively, which is one after another, and 10 years of case. Do you agree that this score sheet is accurate?
Yes, ma'am.
Mr. Dinger, other than what's been placed on the record and what's contained in the admission form, is anyone hostile to the case of entering your admission?
No, sir.
Are you entering this admission with your own free will? Do you feel that entering this admission is in your best interest? Has anyone forced you or threatened you or forced you to get you into this admission?
No, sir.
Are you satisfied with the advice and counsel of your attorney?
Yes, ma'am.
Has he done everything you asked and answered all the questions?
Yes, ma'am.
Has he discussed the violation of probation or violation of community control cases in their entirety, including possible offenses you may or may not have?
Yes, sir.
Counsel, have you reviewed all the discovery in both cases of your client? Mr. Dinger, is there anything about the violation of probation case in either of your cases that you want a chance to review and have not had an opportunity to review?
No, ma'am.
Do you also understand that while you may be entitled to waiting time or time off of your sentence, that there is no guarantee that that will be awarded to you? That's something that's going to be covered by the court of elections.
Yes, sir.
Do you understand that you're not a United States citizen, you may be deported or removed as a result? And you were reported or removed as a result of the condition that cannot be based on fraud or admission. You understand that? Counsel, Mr. Dinger, do you understand that if the offense to which you were admitting was sexually violent or sexually motivated, or if you had previously been convicted of such an offense, it's significantly subject to involuntary civil commitment as sexual offender or sex. Counsel, do you simply report your own court filing affidavits containing your own factual basis?
Those stipulated.
And
I'm sorry.
yeah, and counsel, you also agree that they need compensatory time for it. Now, at this time, the state has the court to do the court filed in both cases, and it's going to be issued in both cases. I've been informed the police form the score sheet as well as a confidential civil restitution.
Mr. Ward, any additional comments or requests? And Mr. Dinger, at this point, after consulting with your counsel, you believe that the certainty of the plea agreement is better for you than the uncertainty and the risk for both the state and for you of the hearing process?
Yes, sir.
Okay. At this time, based on the plea agreement, the plea colloquy, the admitted violations and affidavits related thereto, court accepts the plea agreement. As agreed, adjudications of violations as admitted on both cases concurrent, revoke and resentence to case number ending 1566, 30 months, Department of Corrections with 282 days credit. Case number ending 1612, 25 months, Department of Corrections concurrent with 133 days credit. Prosecution costs of 100 in each case. Public defender charge of 150 total in each case. And all other previous outstanding monetary amounts as well as restitution are referred to collections, with the restitution being the subject of a civil lien judgment. Any other terms to be announced for either side? Thank you for resolving your case. Please step over here. And let me just fill out the orders and then we'll address the remaining cases. All right, it looks like we have taken care of the briefer matters and now enter the part of the docket that is the featured events of the afternoon. Before we do that, let me ask of all counsel present, in attempt to determine what should be the priorities. I do see probation officers here, attorneys, citizens, Mr. McElrath and his client, as well as a law enforcement officer. Greetings. All of whom are probably here for cases. I have Ms. Shakla's case. She is out of custody. I have Mr. DeRochers, who's in custody. I have Mr. Lyons in custody. And Mr. Tacey, who was supposed to be called on or about 3 o'clock, who is in custody. I don't know if we're going to be able to address all of these cases in the time remaining before 5 o'clock. Do counsel have any requests for priority based on what remains? Let me begin by addressing Mr. McElrath and his client, Ms. Shakwa.
Your Honor, my client is local. She is out working. I do have had a potential witness that is helpful. I'm unable to travel at this time. I don't know if that's going to change in the near future. If you want to.
So that would that possibly work any unfair prejudice to the defense?
It possibly could be, Your Honor. Of course, Counter, this has been going on. A rollover is not going to create any more prejudice or benefit to either party, I don't believe.
Now, Mr. Ashby is the attorney, and the probation officer is kind enough to summon him. Thank you. Now, let me just ask the state attorneys that are here, and for that matter, defense counsel too, would any of you benefit from a brief recess to discuss priorities among cases before I come back, or do you want to just address them now? Mr. Ashby, I'm just trying to prioritize the order of these hearings, and I'm trying to be fair to everyone in attendance that is here. And my only concern is we do have a number of contested matters. We're approaching 3 o'clock. I'm not sure if we're going to reach them all this afternoon, so I'm just trying to prioritize them if we can get some type of agreement as to which matters should go before others. Ms. Shock was out of custody. However, Mr. McElrath, you're saying you may have a witness issue?
I have a witness potential who was unable to travel due to health reasons.
Right.
I don't know if that's going to change for.
Are you requesting to go forward today?
No, Your Honor. We're here. My client's not going to go. She's working on a full-time basis. no,
Mr. Ashby, do you have witnesses that wish to go forward today, or are you willing to defer this?
Your Honor, the city would prefer we go today. This case has been dragged on for well over a year at this point. Information. I have conversations here, they're prepared. This case has been called up to and have been set for hearing, at least on 2 or 3 other prior cases. So the state would prefer that this case go here.
All right, so that is requested to go forward. Let me hear from the others, Mr. McElrath, and I'll let you know in just a moment. And let me hear from defense counsel, have clients in custody.
Right now, there's a version in custody. I have, here, to testify to the work I for. I also have a law enforcement officer.
All right,
Your Honor, we do have our witness here as well, who needs to be able to be back to her office no later than before 5 o'clock to be in time.
Okay.
So if that was going to go, that is not going to go, then we ask that we continue to release her. I would also note, Your Honor, that we do have James Lyons, what happened to Mr. Parker. And I have a note here that you asked us to remind you, Your Honor, that we actually moved this case from the last one to this one because we weren't going to get to it. And so I think that you asked that we bring that up to prioritize that.
all right, all right. Let me see. That leaves Mr.
Lines will be short, however, we do not need it.
But you are asking for it to go forward today, is that correct?
We're going to go forward today,
Right.
after.
All right. And I haven't yet seen. We scheduled for 3 o'clock Mr. Chandler on Casey, which is potentially a plea agreement. I'm not sure if it's going to become a plea to the bench. We'll have to wait till Mr. Chandler checks in, Mr. Ashby. Did I miss any case? I think that's the remainder. Based on what I'm hearing, I think I'm going to likely begin with the Rochers because I believe that has the most witnesses here. Am I correct in that recollection that we have multiple witnesses for both sides?
Yes.
So I'm going to start with the Rochers case. I did promise Mr. Lyons, I believe that was going to be a priority, so I am going to need to address that second or third. And Mr. Ashby, with my apologies to everyone, if both sides want to wait to see if we reach Ms. Shakwa, I would do that, or I can set it if both sides prefer on the 14th, because I don't know what the duration is going to be of these other hearings that are priorities ahead of it. I think for Ms. Shakwa's case, the state had a probation officer here. That was.
We have 3.
Oh, 3 for that case. Okay. I didn't realize that. Okay. Well, if everybody's willing to wait, we'll see if we can reach it, unless you prefer to not have everybody wait for the others and come back on the 14th. I don't want to keep anybody here waiting unnecessarily. That's my dilemma.
We are back and forth.
Yes. And the other factor I'm taking into account is that they do involve in-custody defendants, which is another factor. Mr. Ashby.
Yes, sir. I spoke with witnesses. They were going to be in the very close to the block. I know that does have to they will agree to move it into the 14th.
I think that's the better course. Now, are you was this witness that you were concerned about, Mr. McElrath, was that witness going to be available today?
He was, I just found that he can't travel here.
So he could not be here today anyway.
No, he wouldn't
Okay.
be able to be here.
Any objection to the July 14 date?
No, Your Honor, no.
All right, and the officers are able to come back that day? All right, my apologies for the delay. I don't, but it's better than keeping you here all afternoon and not reach you, so appreciate your understanding. July 14, Ms. Shockwell, at 1:30 p.m. for this hearing. I will if you will remind me, like I did at the Lions case, to remember that we have multiple witnesses to give this a priority, and that when it's called. All right, we'll just give Ms. Shockwell a court notice. We'll continue that to July 14. 1:30, yes. Okay. And I believe I indicated well, the only thing I just need to see when Mr. Chandler, do you know if he was going to be in person or by remote?
My understanding, Your Honor, is this was going to be a police event. My expectation was he was going to be here in person.
Okay.
We did not discuss this.
Right. I did tell him 3 o'clock though to reduce his waiting time. But I'm likely to start with DeRocher, but let me see if it's going to be a plea agreement or a plea to the bench. That will affect the decision. Right. So let's take a 5 to 10 minute recess and probably start with DeRocher.
All rise, court is in recess, 5 minutes. Yeah. He screwed us. Yeah.
What's in that bag, guy?
Yeah, guy, what's in that bag? Oh, what's the demanding our nerves? Oh, come here. Where? Come here. No. You come here. I used to watch blue. Peter.
Oh. Yeah. Yeah.
Okay, gentlemen, it's over 14. All right, see you later.
Later.
See you midnight. Oh, you got your agency phone on? No. Well, I'm going to come here and I want to show you something. What? Well, if you come here, quit acting like a.
What am I gonna do with that?
Get over here. See what I gotta do with you, jackass?
You're back in there, file.
Show yourself. Quit acting like a. Over here? Shit. Yeah. This was Kurt. I don't know, but look at what's that say? Separation. 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 Separation.
Little spaghetti bender?
Yeah, how's that dog? Yeah. Good.
Yeah, you're got nothing left to
Can I get out of my 2018 Chevy?
You don't have a Chevy.
All right, our back in
All right, welcome back, everyone. Thank you for your patience. Please be seated. Any sightings of Mr. Chandler?
No sightings yet.
All right, let's begin with the DeRocher's case then. 16 CF 1721. Ms. Mead for the defense, Ms. Mason for the state. That's fine. The call of nature. All right, Mr. DeRochers is present. Hello, sir. How do you say the last name? DeRosier. Very well. All right. And Ms. Mead, how do you wish to proceed?
Your Honor, we're ready.
Okay, there's going to be a plea. Is that correct?
No, Your Honor, we're ready for.
Oh, okay, for the hearing. All right. And it will not be a bench, but it will be a full hearing.
Yeah.
Very well. And is there any preliminary comments from either side?
No, Your Honor, only that, the defendant is a violent felon, something that is concerned. I do have an order from you, Your Honor, which I can forward.
Is that in dispute, Ms. Mead?
No, Your Honor, he's on probation for.
Okay. And Ms. Mason, do you wish to make any preliminary comment or go directly to the evidence?
Your Honor, we're ready to go directly to the evidence.
You may call your first witness.
United States calls here this for years.
And do you wish for him to remain seated at the table? Okay, that's all right. Thank you, Mr. De Rosiers. You can remain seated. Just raise your right hand and be sworn. Thank you.
Oh. Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Well,
Thank you, Mr. De Rosiers. Can you pull your hand? Yes.
Would you say your full name?
there is one children.
And, Mr., I'm sorry, and I apologize, I can mispronounce it, Rosiers?
Yeah, the one there.
There is yours, thank you. Where do you reside?
And when I say
Yes, I mean, yes.
16, 17, I don't know how to say it. I don't know how to say it. Not it's right.
Okay, and I'm sorry, you said 16, 17?
Yeah, 16, 17, 15. Let's go June 7th.
Okay, so how long you served in the Okay, and how long have you resided there?
Basically, I used to just put my eyes just back over there, like, most of them. I don't know exactly that time. It was just like 3-4 months.
Ms. Mead, can you just pull the microphone a little closer to him so we can hear him a little better? All right. And Mr. De Rosiers, is the mask that seems to be slipping down a little bit? Would you like a different one that's a little tighter? We do need to have it. Okay, if you can just pinch it there a little bit, thank you. It's just, that's the rules that we have until the 21st. Thank you.
And sir, how long, with who do you live at 1672 Wall? Okay, who is Esmeralda? Okay, what's your last name? Not sure, okay, how long have you known Esmeralda?
I know that around that after school, it was all the same, like, more
So from high school? Okay, and about how many years is that?
6, 7.
Are you employed?
No.
Do you go to school? Do you have any children?
No.
Do you recall being placed on in case number 16 CF 1721?
My friend got to home with it.
Yes, sir.
Really?
Yeah. Do you remember when you were, do you recall, do you know what they did on that?
On my list?
Yes, sir. And do you recall being placed on probation in that case? When you were placed on probation, is there terms and conditions exposed?
About more.
Just all the different things, all the terms and conditions of probation.
Yeah.
Okay, and when those terms and conditions were exposed, did you understand?
Thank you, Officer Harrison. We'll see if that's a little more comfortable for him. It's slipping down a little bit. All right, we'll try that. Thank you, Mr. De Rosiers.
Okay, and so, I'm sorry, you did understand the terms and conditions of your probation? Okay, and do you recall what of those conditions being condition states that you would not engage, that you would not associate with people who are engaged in criminal activity? And isn't it true that you admitted to obtaining illegal drugs from one of your friends on or about March 9th, 2021? That would have been the cocaine that you admitted to. Okay, and did you recall admitting to your probation officer that you obtained those drugs from one of your friends?
I'm gonna move on, I guess.
You do recall saying that? Okay. Do you recall one of the conditions of your probation being condition 7? You would not possess a drug or narcotic that was not prescribed to you by a physician.
Yes, ma'am.
And isn't it true that you had a positive drug test for cocaine on March 10th, 2021?
Yes, ma'am.
And you admitted to your probation officer that you did use the cocaine that you had obtained from a friend.
Yes, ma'am.
Also, another condition 7, again, that you wouldn't possess a drug or narcotic not prescribed by a physician. Do you recall admitting to your probation officer that you used marijuana without a valid prescription?
Yes, ma'am.
One of the conditions of your probation, you recall it being condition 9, that you would truthfully answer all inquiries directed to you by your probation officer.
Yes, ma'am.
But on January 11, 2021, do you recall submitting the monthly supervision reports?
Yes, I don't see that as
Okay, so you submitted those reports, and on those reports, what address did you recall the address from?
Same address, I think I pronounced it right.
The 1672 Walton Circle address? Okay. And on January 11, 2021, on that report, you indicated that address.
Yes, ma'am.
And is it true that you were not actually residing at that address?
Yes, and that is basically how that's a lot of work schedule is. I do not have to be burdened on other people. But if you work 2 jobs about being enough, that's most of all my belongings that I have.
Almost all your belongings there?
Yeah, I don't have really much.
Okay, and and so while you did, so you stay there sometimes, but you were staying there all the time?
Oh, I do stay there.
Okay, and on January 28, 2021, you also indicated on your monthly report that you were residing at the 1672 Wellesley Avenue address, the one of the circle address. And on February 19th, the same thing? And on March 3rd, the same thing, correct? Okay. And in fact, during each of those, you weren't actually residing permanently at 1672 Wellesley Circle apartment 740.
I was designing it, but at the time, because of how my work schedule is, I do be saying that after I do leave, I do try to go through something. I do try to do something to find something to do at work or anything.
Do you recall condition 9 of your probation also being that you would follow all your probation officer's instructions?
What are the instructions again?
Whatever instructions were given to you by probation, like if they ordered you to do something or instructed you to do something, was your understanding that you were to do that, whatever what they instructed you to do? And on March 4th, 2021, you were instructed to be at your approved residence at 1672 Wellesley Circle, apartment 7, is that correct? However, on March 5th, you were instructed to be there the next morning between the hours of 7 a.m. and 11 a.m. in the morning, correct?
Yes.
But you were not at that address during those hours, were you?
No, I wasn't. Just due because of the virus.
You're not over the question.
Any cross-examination? Next witness.
There's a seat called Sabrina Reiner.
Okay, Ms. Reiner, please come up to the witness box.
That's right. Keep facing clerk, raise your hand, please.
Do you swear or affirm that testimony that you give will be the truth, the whole truth, and nothing but the truth? Yes.
Greetings, welcome back. Thank you for your patience waiting. Yes.
Good afternoon. Would you state your full name, please?
Sabrina Reiner.
And Ms. Reiner, how are you employed?
I'm employed as a correctional probation officer for the
How long have you been employed as a probation officer with the Board of Department of Corrections?
18 years.
And are you the person, the probation officer who's in charge of Pierre Desrosier's files?
Yes.
When was he placed on probation?
He was originally sentenced to probation on August 15th of 2020.
Okay. And when did his probation actually begin?
That would be January 1st, 2018.
And for what was the defendant placed on probation?
He was placed on probation for burglary of an unoccupied dwelling and
And how long was his probation to last?
5 years for the burglary of the dwelling and 30 months for the grand.
Are you currently the probation officer who's responsible for the supervision and maintenance of the probation records relating to your mistresses?
Yes,
Are those files kept in the regular course of business? And was the defendant advised of the conditions of his probation?
Yes.
Did he indicate that he understood those conditions?
Yes.
Were you the person who instructed him on conditions?
Yes.
How did he indicate that he understood the conditions?
My signature on his conditions of probation form.
And was that done in your presence?
Yes, ma'am.
Your Honor, may I prove the witness?
Yes.
Officer Ramiro, I'm showing you what's been marked as State's Exhibit 1 for identification. Do you recognize this?
Yes, ma'am.
And what do you recognize that to be?
His orders of probation.
Are those the orders of probation that were signed by the defendant?
Yes, ma'am.
Were they also signed by you?
Yes, ma'am.
And that was signed in your presence by the defendant?
Yes, ma'am.
Were you the only officer who instructed Mr. Desbrosiers on the conditions of his probation?
No.
Who else instructed him?
Officer James Selson, when he gave his case. Okay.
Okay, and was that before or after your initial instructions?
After.
And how do you know that it's Officer Selson who instructed him?
Because when Officer Selson instructed him, he wrote down that he re-instructed the defendant by putting his name down and on the date that he did it.
And it was that on the same original orders of probation that you had instructed the defendant that you would both sign?
Yes.
Are you familiar with Officer Selson's signature?
Yes.
And is that his signature on that form?
Yes.
Your Honor, at this time, the state would move what's been marked as Exhibit 1 into evidence.
Defense? Admitted?
Your Honor, the state would ask, the state would ask the court to take judicial notice of the court file in CPS 172, including the record placing, 1721, including the record placing on probation.
Any objection?
No, Your Honor.
Granted?
Officer Ramiro, has the defendant complied with all the terms and conditions of his probation?
No, ma'am.
Specifically, which conditions has he violated?
May I refer to the court, to the file?
Yes, you can. If that would that help your recollection?
Officer, are they the same violations in response to question as contained in the affidavit?
Yes. Okay, so defense is stability. Officer, did you file an affidavit alleging violation?
Yes.
What was that affidavit filed? Yes.
The report was submitted on March 11th.
And based on your training and your experience in working in probation, is it your position, do you feel that the defendant is a candidate for continuing supervision?
At this time.
Yeah, this is another question.
And what was the answer again?
No, no.
All right. Cross-examination.
And you have
Yes.
okay, so you indicated that you, when you was released from prison in January of 2019, you are the officer that originally instructed. Yes. And so you have supervised him for essentially a little over 2 years. No. Okay, and was there another officer that supervised him at some point over the past couple of years? Yes. I have supervised him for approximately a month, and he went to Officer James Ellison, and it looks like he had a few officers up until the point where I gained his case back in February. Okay, so just to be clear, in January of 2019, he was from the custody of the Department of Corrections. He reported to probation as instructed, correct, under release. And you advised him of all the conditions of his probation.
Correct.
Okay. When you advised him of the conditions with regards to his residence, he wasn't on community control, correct? He was on probation. Correct. Okay. And it wasn't drug offender probation, it was just regular probation, 40 probation.
Correct.
Okay. And then you stated at some point, approximately a month later, somebody else took over the supervision of Mr. Woodward.
Correct.
Okay. And when did you actually start supervising him once more?
February 25th.
25th of
2020.
2021. 2021. Okay, so for a little over 2 years, he was actually supervised by other officers over there at the department.
That would be correct.
Okay, and during that time period, as the custodian of record of the file, he had no violations. Correct. Okay, never tested positive for any types of substances.
Correct.
Never was rearrested for any charges.
Correct.
Okay. Do you know during that time period, does it indicate what his employment was?
May I refer to?
You may.
From September to current, he was unemployed. In October of 2019, he stated that he worked at Subway. I don't know where. There's no address, contact information, or anything. And August. So every form that we have, it states that he was unemployed, with the exception of that one form. The officer most likely at that time was unable to verify it, and he did not indicate which location or contact number.
So, you instructed him on the conditions of probation. Did he speak to you then about his immigration issues?
I don't remember. the conversation.
And do you recall if he spoke to you at all about his driver's license and the fact that based on his immigration issues, he wasn't able to obtain his driver's license?
I don't remember if we had a conversation.
Okay, is that something that you typically would discuss with someone that you are supervising?
Initially,
Okay,
if they bring it up.
all right, and were you aware that over the course of the 2 years prior to you taking over, or retaking over as his probation officer, that he was able to, on his own, straighten out those immigration issues and obtain a valid Florida driver's license?
I was unaware of that.
And would you agree that, number one, based on your long history with the Department of Corrections as a probation officer, that someone who comes out of the prison system as a convicted felon with these types of charges, and someone who may have immigration issues on top of it, may have difficulty finding home Would you agree with that?
I've had individuals that had issues that have found it.
Okay.
Not everyone, but
Would you agree that it goes
it could be
for,
a factor.
okay, legitimate obstacles for a young man, when he's seeking employment?
Those could be obstacles, yeah.
And are you aware I mean, you mentioned a couple of reports, are you aware if during that 2 years that you did supervisor, whether or not he did hold down some employment at all?
Every form that he submitted to the department has not applicable, with the exception of the one where he put subways, but didn't include any other information like an address, contact name, contact telephone number, or other pertinent information where we could verify all information.
Okay, so when they come in to report, they fill out a form,
Correct.
and how often did you report?
He was on regular supervision, so he would came in once a month to fill out.
Okay, and he never failed to report?
Not that I'm aware of.
Okay.
I'm assuming he
And
did.
so you have 24 individual reports in your file there that don't have any indication that he was employed anywhere?
Would you like me to return?
No, I'm assuming that you reviewed, I'm just asking 24 reports that you reviewed recently.
All of the forms that I looked at, with the exception of one, he put not applicable.
Okay, and my question is, did you look at all 24 forms that you filled out?
I looked at all forms that are in his file currently.
Okay, and are there 24?
Would you like me to count them?
Sure. There should be, right?
I have 23 forms.
So you picked up his supervision after 2 years. I think you said February 25th of 2021?
Yes.
All right. And then you violated him on March 11th, 2021, basically 2 weeks later.
Yes.
And it's your belief that he's not amenable to supervision despite having been supervised successfully for a couple years before he was over.
Yes.
When you called him in for the drug test, told him that he had to come to report to probation, he reported to probation.
Yes.
He must have known he was going to test positive, right?
Whether or not we have our speculations, we won't know that until they actually report it and submit to the drug.
Okay, but he came in and he submitted to a drug test.
Yes.
When you requested him to.
Yes.
And then he basically admitted that he had done cocaine with a friend.
Yes.
And signed an admission form.
Yes.
And you didn't have to send that off to her.
No, I didn't have to send it off with something.
And then,
Redirect.
Officer, during the period of reporting, was the defendant required to come in each month to report during the past year and a half?
With the exception of the pandemic reporting, we had to have specialized reporting for individuals on supervision.
And the pandemic reporting, can you explain what that was?
The department started to go into phasing to limit the exposure of COVID-19. So with regular state probation cases, I believe that they had instructed those individuals to submit their monthly reports via U.S. mail, email, fax, those types of ways, and then to have telephonic contact with their officers on a monthly basis.
So during the time of the COVID reporting, was the defendant reporting, are you aware whether the defendant was reporting that way, not coming in to his report, but actually submitting it? One of the other ways that you mentioned.
Yes, I can tell by the reports that are in the file.
And you testified earlier on cross-examination that the defendant was not on community, correct?
Correct.
But are all probationers required to have an approved residence?
Yes.
And are they able to, other than the residence that's approved by probation, are they able to reside at other locations?
An individual cannot have multiple residential locations.
And was the defendant's approved residence at 1672 Wellesley Circle number 7 here in Naples?
Yes.
Did you ever go to that location?
Yes.
And when you, do you recall the date that you went to that location?
The 5th of March.
And was that this year? 2020? And was that at the point where was that on the day when you instructed the 7:11 a.m.?
I instructed the defendant to be home on March 4th, the following day, between the hours of 7 a.m. to 11 a.m. so I could verify his residence with him there.
And had his residence been okay? And were you able to verify it at that point?
No.
And why is that?
He was not. He was not there.
And were you made aware of whether or not he does reside there?
I was made aware that some of his belongings were there, but he was not really actually residing there.
Thank you. I have no further questions, Your Honor.
Anything else for this witness?
oh yeah.
Thank you, you may step down.
Thank you, Your Honor.
Any additional state evidence?
No further witnesses, Your Honor.
Any defense evidence?
Just one, well, I have a couple of witnesses, Your Honor, but I'm going to call officer first.
All right. Officer, if you can come up.
Very, very brief, and then we get one to Eric Bramblett, which is going to be yourself.
Please report where you are.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
No. Please have a seat in the witness box.
Ratings officer, welcome. Thank you for your patience waiting. Ms. Mead.
Can you please state your full name?
Eric Ramiro.
Can you spell your last name for the record?
BRAMBLE,
And who do you work for?
the Colorado County Sheriff's Office.
How long do you work?
5 years.
And what do you do for the high pension class?
I'm a road patrol deputy.
And are you assigned to a specific area as a road patrol deputy?
The East Naples area.
And as part of your job duties, are you responsible for attempting to serve warrants for violation of probation?
Yes.
All right. And back on Sunday, March 28th of 2021, did you make contact with an individual by the name of Jared Baseball?
I believe that's the correct date, yes.
Okay. And he had an active violation of probation warrant?
Correct.
Okay. Do you recall where it was that you made contact with him?
That is, Wellesley Circle.
Okay, and would that be 1672 Wellesley Circle Unit 7?
I believe that's correct.
I have no further questions.
Cross-examination?
No, Your Honor.
Thank you. Is the officer released by both sides?
Yes.
Thank you. Free to leave. Have a good day. Additional defense evidence?
Yes, Your Honor. Williams.
Okay, Ms.
I
Williams,
don't want to butcher her first name, so I'll let her speak.
can you come up, please?
This one. This one was a key case of burglary.
You swear or affirm that testimony that you give shall be the truth, the whole truth, and nothing but the truth? Yes.
If you please tell us the response, what you're saying.
Hello, Ms. Williams, welcome. Thank you for your patience waiting.
Can you please state your full name and perhaps spell both your first name and your last name for the record?
My name is Esmeralda Williams. My first name is spelled Esmeralda. And
Sorry, what was it? E-S?
Meralda, correct? That's like the character from the Victor Hugo novel. It goes a Hunchback of Notre Dame, Esmeralda. She's in that one. It's a little trivia to add.
Ms. Williams, where do you reside?
1672 Wellesley Circle Apartment, Florida, Florida.
And how long have you resided there?
It's going on 2 years now.
At some point, would you know the defendant in this case, Jared Baseball?
Yes.
Okay, and how do you know him?
I've actually known him way longer than he stated. I've known him since middle school, but it was through a friend. We really didn't talk, but I knew of him. And then we became close once I hit high school, because then we started hanging out together. I was able to go and hang out with friends. So that's when we really started to get to know each other.
And at some point, you were aware that he went to the Department of Corrections.
Correct.
And that was for dwelling burglaries and a bunch of others. Correct. All right. And at some point, he was released from the Department of Corrections. Okay, correct. Okay. And that was that back in 2019?
Yes, ma'am.
All right. And did you allow him to stay at your address 1672 Plum Street for both numbers?
Correct. Actually, prior when he first got on probation, he was also staying with me, residing at 55 Sierra Grand. He was staying with me then. Those 2 years that he was out, that's when he was staying with me.
Okay. So he's always resided in your residence since he was released from
Correct.
And you work quite a bit?
Yes, ma'am.
Okay, 2 jobs?
Yes, ma'am.
As a matter of fact, 2 jobs.
Yes, ma'am.
Today at 4 o'clock. During the time period that he has resided, has Mr. Destroy had a job?
No, but he was very actively looking for one. I was even able to get him an application from mine, but I didn't know how the whole probation thing went. I didn't know if these charges were going to show up. So when I asked him, he was like, yeah, I don't think I'm going to be able to just, he has felony charges. My dad doesn't hire felonies. So right after that, that was out. And then he helped out other applications over to my house that he wanted me to help him with. And we filled them out, and he actually was really like trying. He was trying. I believe he had a few interviews as well.
Okay. And during the time that he resided with you, that he was on probation, did he have some immigration issues that he actually straightened out?
Yes, ma'am.
Okay. And was he able to obtain for the first time a foreign residence?
Yes, ma'am. He was so happy that day.
Now, there's been some allegations from the state government that Mr. Bitcoin did not in fact live in your residence. How often would you say that he was there at your residence? I mean, did you consider him to live in that apartment?
He didn't have a key to the house. So with my work schedule and because it was so conflicting and sometimes like I would be at work, I had 2 jobs. So I would get out of one and go straight to the other one. He didn't have a key. So sometimes I could either wait for me on the patio or I would try to come and give him a key or, try. But sometimes he would just wait or try to sleep with somebody else as well because I couldn't be home.
Okay. Did he receive his mail and other information at your address?
Yes, ma'am.
On March 5th, did you have the opportunity to speak to Mr. Dishboy's probation officer?
Yes, ma'am.
And briefly explain how that happened.
I had just gotten from doing a double, two 10-hour shifts. So when she came, he had already expressed to me like, hey, please make sure that if you can come pick me up. And I was like, I'm gonna try, please just go on my phone, let me know, because I knew I think he was watching the I'm not quite sure. I wasn't able to communicate with him as much as well. So he let me know, can you please? And I said, okay. And then I fell asleep. I was so tired. And she came and I remember greeting her. And I remember telling her that, oh my God, I forgot to pick him up. And then from then on, like the conversation kind of went into a blur because I was still half asleep.
Did you ever at any point tell her that he did not reside there and that you just used that as an address for probation?
Not that I can recall.
Okay. And did he in fact keep things, belongings at your apartment?
Yes, ma'am.
Did he have a lot of belongings?
No, no, he doesn't. He has a duffel bag. That's literally all he has, and he has his clothes in it.
Does Mr. Gilmore have his own vehicle?
No, ma'am.
Okay, so despite the fact that he has a driver's license, he has to rely on his transportation.
Correct.
And were you there the day that he was arrested on the warrant?
No, ma'am, I was working.
Okay. And you were aware that he was in fact arrested at the apartment?
Yes, ma'am.
I have no further questions.
Cross-examination.
Good afternoon, Ms. Williams. So you testified that because of what kind of work do you do?
Well, I was working at the hospital, and then from then I was also working at Aspen Technology, which I operate heavy machinery that makes gun pieces.
And you testified that the defendant does not have a key to your house.
So when I was explaining to her, I was going to tell her like from the beginning.
Well, no, I'm sorry. Your testimony was that he doesn't have a key to your house, correct?
Correct, for that time.
Okay. So that sometimes you would have to either you would have to wait or you would have to try and wait until we could let it in, correct?
Correct.
But there were times when you weren't able to make it, is that right? And you testified that sometimes you would sleep elsewhere because you couldn't be there, correct?
Correct. And when that became an issue, he did end up getting his own key.
Now, isn't it true that you actually told the probation officer eventually that the defendant didn't actually reside at your house?
I don't remember specifically telling her that he didn't reside. Might have said, I can't even remember the conversation. Like I said, I remember opening the door. I asked who it was. There was no answer, so I opened the door and it just happened to be very nice.
Okay, so you're saying you don't recall whether you told her he doesn't reside there or not?
Correct.
I know what it was.
Redirect?
Based on the living arrangement that the two of you had, would it have been likely that you told her that he did not reside there?
I don't want to say yes and I don't want to say no, because like I said, I really only remember like introducing myself to her, and I remember her asking me questions, and even those questions are very, like, I blur, like, I don't remember.
And did you allow her to come into your residence and look?
No, ma'am, she never asked me.
Okay, so she remained outside the residence.
Correct.
Did she ever request to come in the residence and see where his things were, or did she just assume that he didn't live there and left?
I know for sure she didn't come in, because I stayed at the store, and I was sleeping on the couch at the time.
Okay, and had she requested to come in and look around, would you have showed her where his things were?
Yes, ma'am.
Okay.
Thank you. Is the witness released? She needs to get to work apparently?
Yes, sure.
All right, thank you. Drive safely.
Thank you.
Any additional defense evidence?
Can I just have a
Yes. One moment.
That's Money Reaches Office.
Hold on, Melissa. Did Mr. Chandler attempt to reach you?
I do have a voicemail. I can check it right now.
Okay. Mr. Ashby, I'm just checking on Mr. Chandler. You have any update?
Yes, sir. This trailer currently waiting on.
Okay.
I don't know if it's gonna happen.
All right. So that was just, I think, a breakdown in communication. Melissa, are you able to provide a Zoom code to Mr. Chandler?
I don't think so. We didn't have Zoom codes for this afternoon. And I would have had to have generated them.
Okay. Could he appear telephonically? If you, can you reach out to him and see if he can appear telephonically, or did he say what he was going to do, Mr. Ashby?
My understanding is that he's currently on Zoom, and waiting room. He might be using this morning's, Zoom app.
Right.
That's it.
So we had continued the hearing, Melissa, and we weren't sure if he was going to appear by Zoom or in person, but this is not a Zoom event?
Right.
Okay. If you could ask him if maybe at 4 o'clock he might be available by telephone.
Okay.
Thank you.
You're welcome.
All of the minutia of connections.
Yep. Never ends.
Ms. Mead, any additional evidence?
Yes, Your Honor, one time.
All right, and he's been previously sworn. Mr. Sears, you remain under oath at this time. So you've already been sworn, just you're already under oath. Thank you. You may answer your attorney's questions. Any objection, Ms. Mason, if you questions from the table? All right. Or you can do the podium, whatever is more comfortable for you. All right.
Okay, Pierre, at some point you were released from purpose, right? And immediately from the release report situation, and was that back in 2000? And was that the probation officer that we saw the first time? At the time that you met with her and went over the orders of your probation, did you discuss with her certain issues like your ability to be able to get help?
With that, honestly, you just from the movie and release, I figured out, like a particular thing, and then to me finally finding out what's going on, I only had things for like a short month. As soon as I got my address, there was another location before I moved. It was over there by Green Boulevard, and then that's when Manalich ended up taking over my face. And then I remember discussing the issues with him once I finally figured out what's going on with my father and everything. Along my immigration status, and then that's like one of the main reasons why I was able to job. That's one of the problems came up. Because due to certain identifications that I have, and certain long periods of waiting time I had waited for immigration time, get my paperwork, and I have no family myself. Basically, like, acquire certain things from immigration. I had to put my social security card, and my green card I had to get removed and everything. Part of the stuff. Actually put in to apply for my license. But I already completed another alcohol course, like polygraph, like when I was in high school. It was one thing I was missing. I never had a good course that and I acquired that when I got released. I just wait for months. My mind came up on it, no way to do it. After I got some language to out.
Okay, and so you squared away your immigration? Yeah?
Yeah.
Okay, and you were able to obtain permanent resident status, and you obtained a Florida driver's license. And during the 2 years that you were being supervised on probation, a larger part of that was consumed by the COVID-19, correct? During the time that you were on probation, did you intensify employment?
Yes. There's actually one other spot I didn't mention. I was on a place called Blazing Syria. It was like a little moving company. And one of my friends actually had recently got me in contact with Dave. And then he was giving me a job, but it wasn't consistent. It was whenever he needed the extra hand or nothing else. So it was something that gave me like this straight cash. It was nothing else. Just marked down on I put the tax. So any taxes on anything. But it wasn't really a consistent job. It just called me like all months. I speak maybe 3 years.
Okay. And was it difficult finding employment when you got out of prison with immigration issues?
That's the word, but I didn't have no form of
Okay.
ID.
During the 2 years that you were on probation, you reported regularly, and you were residing with Miss Williams. And were you always there at her residence?
Yes, whenever the student there or there, I was in the
Okay. And was all of your like mail and whatnot being sent to that address? And in fact, you were arrested at that address on the violation of probation warrant, correct? When you reported to probation on March 9th, as requested, or to March 10th, as requested by your probation officer, Ms. Driver, you went right in, correct? All right. And you tested positive. Did you admit to Ms. Driver that you had in fact used cocaine the day before, and that you had been with friends and that? Did you speak to Ms. Reimer at all about getting help with regards to the substance issues?
all I remember was basically getting my Facebook engagement, and then I didn't actually know about Florida until like I think I had got a phone call with Ramiro telling me that they was looking for me. And then from there, that's when I found out Florida had an idea about like I do remember the college degree, but still was so when up.
Okay, so she didn't tell you when you were in the office that day that she was going to issue a warrant for your arrest?
I actually had no idea.
And as soon as you learned that they were looking for you, you made sure you stayed in prison. Was there a time that Ms. Reimer came to the residence at Wellesley when you were there?
There was one time he did show up and I was outside. And then I remember at first I was struggling to get in contact with us around. And then once I finally did get in contact with her, I ended up finding the key to the back patio. And I did on my last to come inside. She did look around. did speak up for my that mom was there. But I guess there's one time she was present. I was sitting outside, and she seen how struggling this week, whatever, and it was last minute, she finally took it home, and I was able to finish the business style, show her what my belongings was at, told her I was staying at that, and she had a meeting. And I remember me and her had, also had talked about, like, matches that are optional too. There's no lie, as much as I didn't want to be a burden on that lot too, and her work schedule too, we did talk about like matches, whether it's I was going to go there and I could that. We did try to give me contact information, whether or not I want to take that route. That was one thing we did talk about.
Okay. I have no further.
Any state questions?
Yes, sir. Sir, you testified that you could work on the movie.
Yes, ma'am.
Or what was it, blazing?
It's called Blazing.
I'm sorry, blazing.
Blazing.
Blazing interior, okay. And your testimony was that was 1 to 2 times a week?
I don't want to count. Whenever we get in the car, it was random.
I'm sorry?
It was random. Like, it was random. It wouldn't be like all like steps.
Okay, but it ended up being a couple of times a week that they ended up meeting?
Most 3 times a month.
Okay, and then you were getting paid for the days that you worked, right?
Yeah, 120.
Okay, but you never put down on your monthly report that you had worked anywhere during this time, is that correct?
Yeah, I never put it down.
Okay, you also, testified that when you learned that the police were looking for you by, receiving a phone call because Esmeralda had called and told you that they were looking for you, correct? And it was at that point that you went to her house and waited for law enforcement, correct? But your testimony today was that Esmeralda called you to tell you that the police were looking for you, correct? But my question is that you testified today that Esmeralda called you to tell you that the police were looking for you, right? And at that point, you went to Esmeralda's house, correct? And you waited for the police to get you. Okay. And during, with your monthly reporting, do you recall that sometimes you were doing the reporting by, how were you getting all of your monthly reports in?
I was doing I had Russell Bolton. Russell Bolton was planning to do it. He was telling me to fill it out and take a picture and send it to you.
Okay, and so you sent, did you do that a couple times?
Yes,
okay, and were you also recording by phone?
Yes,
okay, and during the time that you were taking the photo of that document and you also recording by phone, did you have to undergo any drug testing during that time?
It'll be done in me, but I'm not, I don't know that date.
No, that's okay, you don't have to remember the date, but just during the time, and I believe it was during the COVID protocols, when you were having to take a photo and you were recording by phone. Were you being drug tested during that time as well?
Yes, no, I was. I know Russell did call me, and I did go. I know that one time as well.
Okay, I have no further questions, Your Honor.
Any redirect?
Just to clarify, so you were living at the residence at Wellesley and you were away from the house and Esmeralda called you and said, law enforcement officers were here.
Yeah, they came.
Yeah, and you weren't there at the time.
Yeah, I was there.
Right, and so you went back there because you knew they were looking for you. Okay. No further questions.
Okay, any additional witnesses?
No, Your Honor.
Were there any additional questions?
No, Your Honor, I was just waiting to see if Mr. Young had other questions.
All right, no additional witnesses, any state rebuttal evidence?
Yes, Your Honor, statement calls for Your Honor.
All right, Ms. Reimer, please return. Previously sworn.
Please watch your step.
Good afternoon again, Mr. Also, Robert, when you went to 1672 Wellesley Circle, Apartment 7, on March 5th, 2021, did you make contact with Esmeralda Williams?
Yes.
And it was in fact Esmeralda Williams who told you that the defendant didn't actually reside there, isn't that correct? Okay. And what did she tell you as far as the defendant staying there?
She said that he kept her key belongings in a duffel bag, and I did not go to the apartment, but I could see from the doorway his bag where it was located. She showed me that via where she was standing.
Okay. And so she said that it's her testimony that she told you that you had some belongings there. And did she tell you that he didn't actually reside there?
Correct.
And did she give you any information as far as an arrangement about taking him up or anything like that?
She apologized. She said that she had worked double shifts, that she had talked to him about me showing up the next morning. I guess they had made an arrangement where she was supposed to have gone to pick him up. But she told me that she didn't realize that I would be there as early as I was, that she didn't have an opportunity to go get him.
And when you reported when you went to that address on March 5th, was that to do, I believe you testified earlier, that was to do a home verification?
Yes.
And had you ever been able to, prior to that day, what was the reason that you asked the defendant to be at that location during those hours for the home verification?
When I moved his case for supervision, I noticed that previous attempts made by his prior supervising officer to do random home verification checks had all failed. So at that point, if so many attempted personal contacts are made, the department requires us to set up an appointment with that individual to be home. So when I did speak with him, I instructed him to be at the residence on that particular date during that time frame so I could physically see him.
And do you recall approximately what time you arrived on that day?
It was 10:16 a.m.
Okay, and was that within the time period that was instructed to be present?
Yes.
And prior to the March 5th home verification that you attempted, had you ever been able to make contact with the defendant in person at that location?
Well, I started supervising him on February 25th. And I believe the first time I was able to talk to him was over the telephone, and that was on March 4th.
Okay.
So I did not make any attempts prior. I just had instructed him to be home on March 5th.
Okay.
The failed attempts were made by other officers.
Okay, but so for you yourself, and I'm sure you heard the defendant's testimony as well, you yourself had never actually, prior to March 5th, had never actually been to that house and made physical contact with the defendant. Is that your testimony?
Correct.
Okay. And the defendant, following that, the defendant didn't ever actually lead you through the house to show you his belongings. Is that correct?
May I make a clarification?
Yes.
This occurred after the violation.
One moment, counsel. Hello, this is the courtroom. Mr. Chandler, are you connected?
Yes, sir.
Yeah, sorry for the confusion over the Zoom. I'm just finishing another case. If you can hold on.
Yes, sir.
Thank you. Please continue.
I'm sorry, you were making clarification.
I do have to apologize. I do not remember the exact date, but I did speak with him. I did instruct him after these violations had occurred to be home. And so I had gone back after this. And when I got there, he was outside.
Okay. And so was that after the March 5th?
That was after the March 5th, where he stated that he was outside, he had no way to get in, he said he was sleeping somewhere outside all night. And he couldn't find the key to get into the apartment, and he eventually found it. And then he let himself in, and he let me in, and we had this discussion about St. Matthew's house. So that did occur, but it occurred after the.
I have no further questions.
Anything else for the witness?
Just briefly, so on March 5th, when we were there, you said you did see his daggers belonging to the apartment.
It was, yeah, one duffel bag.
Okay. And then at some point after that, you were at the residence once again,
Yes,
and you had a conversation with him. He was at the apartment when you got there.
he was outside of the apartment.
Okay, and did you know you were coming?
I believe I instructed him
Okay, and this is after you had violated him?
after the report was.
Okay, so on March 10th, you violated him, correct?
I submitted a violation.
Okay. And a warrant was issued.
Yes.
And at some point after doing that, you made contact with him at the Wesley Acre,
Yes.
and you saw, and he brought you in and showed you that he had belongings there.
Duffel bag.
Okay. And did you ever tell him that there was a warrant issued on him? Did you ever tell him you had violated him or that there was a warrant out there?
No, I didn't.
Why not? Why didn't you take him into custody then? Why didn't you arrest him in the office?
I'm not a certified PCSO law enforcement officer. I can't just take somebody in custody, put them in the back of my car and transport them to the sheriff's office.
Okay, but you can call the sheriff's office, and you have in the past.
That would have been placing him under warrantless arrest. We did not do.
Okay, you've done it in the past.
But I did not do that day.
Okay, so you must not have considered him a danger to the community. He was out there with a warrant, you knew where he was, and you didn't call law enforcement to come pick him up, or you didn't, take any steps at that point. You let the law enforcement officer actually provide her a couple times on the rest at one time, correct?
I don't understand the question.
Okay. Had you considered him a danger to the community, you probably would have made sure that that warrant was executed on the day you went to visit him. Right?
I'm sorry, may I ask a question? Does this have
I
anything
think I
to do
asked you a question.
Can you be more specific with the question?
Came into your office on the 10th. You had a conversation with him. You drug tested him. You tested positive. You submitted a warrant on the 11th. At some point after that, after the warrant was submitted and authorized, you went out to his residence. You visited him. He was at the location that he indicated he resided at. You spoke, had a conversation, saw his funds, spoke to him about possibly going to St. Matt's, maybe that would be a better living on him, correct?
Yes.
Okay.
You're asking me why
there was a warrant, correct?
You're asking me why I did not place him
No,
under.
I'm asking you. Did you believe he was a danger to the community?
The decision to place somebody under warrantless
No,
arrest.
excuse me. The question was, did you believe that he was a danger to the community?
Are you asking me that?
I'm asking you that. Yes, as a
Violation
probation
of
officer, supervising us all these years of experience, did you believe that he was a danger to the community?
He violated the conditions of his supervision.
Okay, that's not what I'm asking you. I am asking you, listen to the question. Did you believe?
Objection, Your Honor, this argument is also irrelevant.
And Ms. Mead, you can restate the question, but please lower the tone.
I'm sorry. Did you believe that he was a danger to the community based on your experience and training as an officer with the Department of Corrections for 18 years?
Your Honor, I object again, this is an irrelevant question. The question is, the determination is not whether or not he's a danger to the community, but whether or not he violated the conditions.
What's the responses to the
I would agree,
relevancy?
Your Honor, except they have specifically made it a point to designate him as a violent felony offender of special concern, and as Your Honor is aware, if Your Honor does find that he is in violation, I don't know that we're necessarily arguing
Well, the objection sustained at this stage of the proceedings, I don't think it's relevant.
Well, I won't have her testify as then. So if I could have some.
Well, in order to avoid, I don't know if we're gonna get to that stage or not, I have to make a decision first, but in order to avoid Ms. Reimer having to be recalled if we reach that stage, I will allow an answer on that, but not consider it as far as the violation.
Yeah, I would agree.
So, Ms. Reimer, do you consider Mr. DeRosiers a danger to the community because of anything that you are aware of in this case?
That's a difficult question to answer because I haven't been supervising him for that long. But because he was statutorily designated as a violent felony offender of special concern, this is something that the department has to acknowledge when we're supervising the individual. But I can't make determinations of whether or not he would do anything forthcoming if he's released. That would be the court's determination.
Anything else, Ms. Mead?
No.
Any additional questions from the state? Thank you, Ms. Reimer. You step down. Any additional evidence?
None of the state.
All right. Let me interrupt a moment. I do need to address Mr. Ashby and Mr. Chandler. So we can just take a break on Mr. DeRosier's case and we'll return to that. And if you want, we can have him return a little bit later. Let me address Mr. Casey's case. Mr. Chandler, can you hear us?
Yes, sir. Thank you. I apologize for the confusion.
Yeah, well, the court's apologies also. I think we just forgot about the minutia of the Zoom codes, and this afternoon, I think it was set up to be a Zoom event. I think that's what happened. We all kind of assumed it might be. So anyway, let me have Mr. Casey brought out. And let's see, this is from this morning, and it's case number.
That's 16, yeah.
Thank you. All right, welcome back, Mr. Casey. Please be seated. Mr. Chandler is connected by phone. There was some earlier confusion, Mr. Casey, about whether he would be able to connect by Zoom or not, so we were somewhat delayed from the 3 o'clock hour. But Mr. Chandler can hear us and participate. Mr. Chandler, what's your understanding as to how Mr. Casey wishes to proceed this afternoon?
The way I understand it, Mr. Casey wishes to enter a plea to the court. The state had offered 70 months. Mr. Casey, I believe, is asking the court for 68 months. Pursuant to the score sheet, he scores 66 months. So both would be guideline sentences, whether it's 66, 68, or 70.
All right. And Mr. Ashby, what's your understanding of, now, at this point, if there is a bench plea, the state plea offer was for 70 months?
That was correct.
And the minimum is 66?
Yes,
And if Mr. Casey chooses to not accept the plea agreement and do a plea to the bench, the state obviously is not bound by any previous recommendations, including the 70 months. It may request anything that it believes is applicable under the law and the facts. Is that correct?
That's correct.
And Mr. Mr. Chandler, Mr. Casey understands that?
Yes, Your Honor.
Yes,
And he has acknowledged, right, he's acknowledged that. So, how much evidence or hearing do we need to address the issue? How much time do you think may be involved, Mr. Chandler?
I would anticipate 10, 15 minutes. I would defer to Mr. Ashby, though. this shouldn't be a long hearing, 10 to 15 minutes.
So we would do a plea colloquy, and then are we going to hear any evidence or argument only?
Really just argument. My client, I'm sure, is going to want to address the court.
Okay. And Mr. Ashby, how much time do you think may be involved?
Yeah, I would expect 30 minutes total for both sides. I would agree 15 minutes on the state side. There would be no witnesses on the state side.
Okay.
There's one issue now at this point is the fact that Chandler is over the phone. I think that is a problem. Hopefully
Under the request that Mr. Tacey has, Mr. Chandler, when would he be released under that if his request were granted?
If the court granted the 68 months, by my calculations, he would be transported to DOC and released within, I would assume within days, because he would have that in.
Okay. Now, the reason I ask that is because at one point, we had the competency issue and we resolved that so we can move forward.
Yes,
at one point, was it anticipated this would be a plea agreement, or was it always considered to be a plea to the bench?
It was anticipated it was going to be a plea agreement.
All right, that's why I thought it was put on the morning docket. And I've tried to expedite it, put this afternoon. My only concern is, and I'm just going to ask Mr. Ashby and Mr. Chandler also, is there any possibility that the half hour that we need to resolve this and have the court make a decision, would you both be available on Friday afternoon? The reason is that I have two other cases, one of which I had promised Mr. Barger we would reach his case this afternoon. Is that problematic for either side? That would still put us very much in a time frame that both sides are asking to address.
Yes, sir. I could do Friday morning or Friday afternoon, whatever the court's pleasure.
What about you, Mr. Ashby, in the afternoon?
I'm available in the afternoon. I do have to leave, Your Honor, on the 11th. And, but I'm not sure.
Okay, Mr. Tacey, did you have a concern about
I had a concern. I thought that I was under the assumption that, by form of practice, that if I was under time served, then, and I pled to that, or the court allowed that, that the order would substantiate the release from custody. So I wasn't aware of that. Still, regardless of the circumstances, I would have to go to the Department of Corrections just to be released from custody. So that was something I wasn't aware of.
Right.
Just on new practice.
Okay, does that affect your decision to do a plea to the bench in this case?
No, it does not.
Okay. What I wish to do then is to set this matter to finish on Friday afternoon, which is just 2 days off, only because I've run out of time this afternoon to complete the things I want to complete. So let me see if we can set this. Are you both sides available at 1:30 on Friday afternoon?
That would be fine.
All right. Let me just check with my assistant, make sure.
Judge Manalich, office.
Hello, Melissa. In order to finish the Tacey case, we need 30 minutes, and I have other things I need to complete today. Can we set it for 1:30 on Friday? Both sides are available. Mr. Tacey would need to be in person.
Yes.
Okay, and we'll finish it on Friday afternoon, Mr. Tacey. Thank you for your patience. Thank you, Mr. Chandler.
Thank you, Your Honor. I'll see you Friday afternoon. We'll see that see it on Friday.
Yes, Friday afternoon, 1:30. If you can be in person, please.
I will be. I will be there in person Friday at 1:30.
Very good, thank you. Ms. Mead and Ms. Mason, before we recall Mr. DeRosiers, how much additional time to finish on this case? Well, my only concern is I did promise Mr. Lyons that I was going to finish his case. Let me ask, are both sides able to, how much additional time do we need? Okay. Mr. Barger, are you able to either go forward today or on Friday afternoon? Okay, who is your opposing counsel? Ms. Mason? Okay, you got all the heavy lift. So Ms. Mason, you are available on Friday. If so, by inclination would probably be Mr. Barger. I will bring out Mr. Lyons in a moment. but if you're able to address this at 2 o'clock on Friday, then I can tell Mr. Lyons and Ms. Mason's available that we can finish his case on Friday at 2 o'clock. So let me bring on Mr. Lyons now. Melissa, are you still monitoring?
I am.
Okay, so we'll add that one on Friday, and then I can finish while I'm fresh in mind with Mr. DeRosiers this afternoon.
And what's going to be heard on the Casey case on Friday?
It's the plea to the bench,
Okay.
and the same from Mr. Lyons.
Okay.
One moment, just to address that with Mr. Lyons. Okay, Mr. Lyons now present. Hello, Mr. Lyons, welcome back. And thank you for your patience. You can have a seat there, Mr. Lyons, thank you. Thank you for your patience. I have signaled your case as a priority. However, I had some conflicting priorities this afternoon, and I would, if necessary, I would have addressed it to finish today, but I have time on Friday, 2 days from now at 2 o'clock, which won't be as rushed, and I'll be able to fully hear you and the other side. So I just wanted to explain that to you, and thank you for your patience. But Mr. Barge is available, Ms. Mason's available, and we can give it better attention at 2 o'clock Friday. All right, we'll see you then. All right, then we're ready for Mr. DeRosiers.
How much time are we setting aside for the Lyons case?
Mr. Barger?
I'm gonna estimate, 35 minutes.
Let's assume 45 minutes on that, Melissa.
Okay.
All right, thank you. All right, we'll continue and finish with Mr. DeRosiers. And Ms. Brown, you're not waiting for anything? Okay, want to make sure. And the lady in the audience, you're watching the DeRosiers case, all right? All right, Mr. DeRosiers is back. All right, welcome back. Ready to resume. I believe we had completed the evidence, is that correct?
Yes.
All right, does the state wish to begin?
Yes. Your defendant was placed on probation in this case, and he violated it in a number of ways. Positive drug testing for drugs, admitting to probation that he got the drugs illegally, and the fact that he, on 4 different occasions, listed an address on his monthly report where he did not actually reside. The state's position is that just because a person visits a home doesn't mean that they reside there. He can have his mail done there, but he's still not residing there. I think that was obvious from the testimony. Even from the defendant, from the, I don't know if she's the renter or the homeowner, Ms. Williams, and from the probation officer. Starting with with Officer Ramiro, testified that all the probation officers that had this case before her, none of them have been able to verify the defendant's address at this location, which is the reason that she scheduled the appointment to require the defendant to be there at a certain time, and he wasn't there. She spoke with the homeowner, Ms. Gonzalez or Ms. Williams, and Ms. Williams testified. She stopped her short of being untruthful and telling the court and testifying that she doesn't recall whether she told Sabrina Ramiro that the defendant wasn't actually residing there but had some of his stuff there. There would have been no reason for Officer Ramiro to go into that house when the homeowner told her that he didn't reside there, but said that he had this duffel bag, which Officer Ramiro testified could clearly see there in the hole. The homeowner, the renter, Ms. Williams also testified that the defendant didn't have access to her home unless she was there. That's not a residence, Your Honor. She would try to let him in, according to her own testimony. She would attempt to let him in, but if she couldn't let him in and he couldn't wait, then her testimony was sometimes sleep other places. His approved residence was the 1672 Wellesley Circle, Apartment 7. He was not permitted to sleep in other places. The defendant even testified that there were times where he could stay other places. But that's not what the agreement was with probation, and that's the reason the probation can approve it to the residence.
All right, additional?
Yeah, sorry, I heard a long pause. There was testimony from Corporal Graham at the sheriff's office that he arrested the defendant at this location. But the testimony from Esmeralda Williams and the defendant was that Esmeralda had to call the defendant to tell him that the police were looking for him. And that is the reason why the defendant was actually arrested at his Colville residence. It's because he was put on notice that the cops were looking for him, so he ran over there and then waited for them to come, and waited for them to hear it so that he would actually be present when they arrived. But the state would argue that that was not his residence, and that's not where he was living, that's not where he was sleeping every night, that's not what all the information had proved that he did. Now, there's a lot of testimony about the defendant having a difficult time finding a job and finally getting a driver's license. But the defendant's not charged with any of that. His charges are drug related, his charges are engaging, associated with people who are engaged in criminal activity and filing an untruthful report with probation. And then not being present when probation ordered him to be there and he wasn't present there. It has nothing to do with him not being able to get a job. So while he does still owe quite a bit of court costs and cost of prosecution and over $8,000 in restitution, there's been no allegation of him not being, of him violating those. And I believe that may have just been because, according to Officer Reimer, all of the reports that she had from him indicated that except for one month, he wasn't employed. So those would have been local violations, so he's not charged with those. However, the state would also note that the defendant did testify that he worked for another company. And according to Officer Reimer, he went through, at the request of his he went through all 23 of the defendant's monthly reports and confirmed that he only on one of those 23 indicated that he had held down a job. And that was 1 month for working at Subway. He never even indicated that he had these other jobs, or any of these other jobs. So even that alone, Judge, is not being truthful on his report. For those reasons, Your Honor, the state would ask the court to revoke the defendant's probation. He does score to prison. We would ask that he be sentenced to a 48 months in the Department of Corrections.
Okay. Ms. Mead?
Yes, sir. So I think, Your Honor, our residents, it's probably different things to different people.
They're what?
I think our residents may be different things to different people. If you're making $80,000 a year and you have a home that you rent and can go to every single day, you would be there every single day and have all of your mail sent there. That would be your residence. If you can't get employment because you have immigration issues, you're a young man just out of prison, convicted of a burglary, and you're having problems actually finding employment. If you can pick up a random job here and there and make $120 to cover maybe your food, but it isn't going to cover certain rent. Maybe a residence is at a woman's house who works 2 jobs and allows you in the house when she's home, and where you keep your things, and where you receive your mail. The interesting thing is that's the address, Your Honor, is in the court file that the state asked you to take to this remote site. That's his legal address. That's his residence for the purposes of probation. There is nothing in these probation orders that says you have to be in that place 24/7. Miss Williams actually rents that apartment, and she sounds like she's there maybe 4 hours a night. She's working 2 10-hour double shifts. It's still a residence. And I would submit to you, Your Honor, that was considered your estimate residence as well. So with regards to those particular violations, I would submit to you that you did not, in fact, violate probation. And, you know, the state says, oh, there's several violations. I mean, basically what this boils down to is a dirty drug test. And the probation officer violated him 1, 2, 3, 4, 5 times for unlawfully and untruthfully reporting on his form that he resided at that residence. January 11th, she wasn't even supervising him, according to what she said. She started supervising him on February 27th. And she only had one contact with him. Or spoke to him for the first time on March 4th over the phone, and then had one contact with him in the probation office. So I would submit to you, Your Honor, that her testimony was as of March 25th, she didn't believe that he resided at that residence. And she has violated him for that same violation.
Are there, go ahead.
5 times on 5 different days.
Are there any violations not disputed as alleged as me?
Your Honor, the only one that there's 2 that we would not. Violation of condition 6, and then he did admit to his probation officer, and he admitted that he did some cocaine with a friend of his on March 9th. And he filled out an admission form when the probation officer talked to him about that.
So that's the condition 6, and which other one?
6 and 7.
Okay.
With regards to the second violation, condition 7, there was no testimony from the probation officer here today about the marijuana. There were no lab reports presented about the marijuana, and the admission form does not mention marijuana. So I would submit to you that the state was not prove that violation. So we're admitting basically that he did violate condition 6 and condition 7 on March 10th, 2021, after being out of probation for a year.
And what's the defense request if we, as to all of that?
Well, yeah, by this violation of condition 9 with regards to the driver's testimony that he'd be there at the residence on March 5th, in specific hours, Your Honor, I would argue that he was not in fact there. It was not a local violation in that he does not have a vehicle to get to the residence, and he testified he was unable.
That's the condition 9 about being instructed to be there at a certain time?
Yes.
Okay.
Would you like us to argue with regards to?
Well, the state is,
the
state, I have to find the violations, but the state has asked, or preliminarily alluded to what they're requesting, which is the revoke and resentence, and Department of Corrections 48 months with obviously credit any time served. But what is essentially the defense request? Because some violations are admitted.
Yes, I would agree with that. But for the fact that he was on probation for burglary of the dwelling, this would have been a technical violation that would have been handled through the alternate section. They are all technical violations, even if you were to believe that he violated all 10 of the counts of probation charges. And that's including a positive drug or alcohol test. I understand that because he is considered a violent felony offender of special concern, that the court has to look at certain things with regards to his history, the nature of the violation, which I'm arguing are basically technical. Well, they are referred to in the statute, these violations, as low risk violations.
Well, let me just stop a moment there and just, at this point, before we get into a full-blown discussion of what disposition the court should do,
okay.
Let me just have you initially just limit it to, like the state did, essentially, based on the violations you do not dispute, what are you requesting?
I am requesting that his probation be modified, Your Honor. I am requesting that the court make a finding that he does not pose a danger to the community and threat staff.
What would be the nature of that modification?
To modify it to include a substance abuse evaluation and perhaps some counseling. And I think you could benefit from that.
The other terms remain the same?
Yes, Your Honor.
Okay.
he has, you know, taken care of his immigration issues. He now has a driver's license. He has been actively.
All right, and we'll come back to that, but at least I know essentially.
My argument with regards to that would be it would benefit the victim as well, because he can continue to make an attempt to pay restitution. I don't think he's gonna have to do that now.
All right, well, obviously, any other preliminary comment on the violations at this time from the state?
Yes, Your Honor, we can speak about our meeting, the third video evidence, submitted, about the marijuana violation. The defendant did testify, he admitted, that he had used marijuana and then admitted it to the probation officer. We would also argue that all of the Condition 9 violations were willful. And I know that Ms. Mead is arguing that him not being present between 7 and 11 a.m. Was not a willful violation. However, Your Honor, I think that just also goes to show that the defendant was not residing there. He wasn't, that's his approved address where he's supposed to be sleeping. He's not there. He wasn't there between 7 and 11 o'clock in the morning, but he knew that he was supposed to be there because the officer had made an appointment for him to be there during that time. Understanding he may not have had a driver's license, but he had a way to get to wherever he was, and he knew he had an appointment there during that window, and he chose not to do that. So the state would argue that there was a willful violation for each of these. And also, Your Honor, that when Ms. Williams said that the defendant did not reside at that, that he actually didn't reside at that address, each time he put that address down for these Condition 9 violations, every single time he put that address down, it wouldn't have been a violation because each time it was an untruthful statement. So the state would argue that each of these is a willful violation, and that we would ask the court to find a violation for all.
We've had a vigorous and extensive hearing, and there's a part of this that's not disputed. There is part that obviously both sides are arguing pretty strenuously as to whether those violations have been proven. I would like to look at the probation order carefully, as well as my notes from the hearing on the violations. And Ms. Mason, you're going to be here on Friday. Ms. Mead, any possibility we can finish this on Friday?
Can we, Your Honor, my father's birthday on Friday.
Okay.
It's 3 hours away. And
No, we don't have to put it on Friday.
I have, because it could affect if he's released or not, and so I would like to do that Friday. I'm hoping to do it Friday morning.
I don't think so. I think there's quite a bit. Let me just check. Ms. Mason, are you here on Friday morning?
I know we have there's a complex on Friday morning.
Right. Yeah, that's my concern. That's why I'm not inclined to do that, but I certainly can, if Ms. Mason's available, I can fit it in early next week.
Or if I can hear you Zoom. I don't have a problem with that, and
Any objection to appearing remotely?
I don't have an issue with that, as long as the that's okay with that.
I can either set it for next week, Ms. Mead, when you can be here, or I can set it for Friday by.
I can do it Friday, by Zoom. I do have a police that on Friday, it's 10:30.
And what?
17.
Right, it's just a very full morning. And,
Oh, it is, okay.
Yeah, that's the problem.
Okay.
So again, whatever you prefer. Do you prefer to be here next week when we can set a time next week, or do you want to have it by remote? All right, let me set it right now. And I will be prepared to make a decision without any further delays on that.
Judge Manalich's office.
Hello, Melissa. The final case that we need to finish, I'm assuming from the parties, it's just for me to determine the violations. Are there any other complications, Ms. Mason, that you noticed? So is the state available next week? I was going to put it on Friday, Melissa, but that's problematic for Ms. Mead and her client. So we're looking at next week.
It would have to go on the VOP docket.
that's fine. Right, and Ms. Mead, you can appear either, well, you're choosing to appear in person.
Oh, I'm fine, if anytime.
Okay.
I have a 1:30, chief administrative conference with Judge Kyle and Kurt Myers, but it's via Zoom, so
Does the state prefer the afternoon or the morning?
you're on, I'm on both offices, so I did.
Okay, so you can do it either one. Ms. Mead, do you have a preference?
No, she refers to me,
Well, then probably the afternoon. Now, what time is your Lee County appearance?
it's a 1:30, but honestly, Your Honor, I can step out.
Okay.
Here, via Zoom.
So Melissa will add Mr. DeRosiers for 1:30. That's on what day of the week?
That would be Tuesday, June 15th at 1:30.
All right. And I'll make my the complete decision there. I'll announce my decision on the violations. I already have a preliminary indication from both sides. I'll hear any additional comments and make a final decision. All right, thank you for your patience. See you on that occasion. I believe that completes the docket.
Yes, sir.
All right, thank you, Melissa. Bye. And we are adjourned at this time. Thank you.
Thank you, Your Honor.
Goodbye.
For your patience.
Yep. It's a matter of a lot of sorting. But we didn't have people wait unnecessarily.